All right, well, we are waiting just for a few more people to join. We have a large crowd today, and thanks everyone for joining us. This is going to be a really great presentation. So, let me formally introduce you to the Saul Ewing update on recent trends in title and policy coverage claims. We're glad that you're here. My name is Trip Riley. For those of you who don't know, I am a partner at Saul Ewing. I am the co-chair of our Consumer Financial Services practice group, as well as the chair of our title insurance practice group. And we have a great group of presenters today. First is going to be Bob Gill and Melissa Clark, and they're going to be discussing what's new and what's still the same in title and policy coverage claims. As we all know, that's the first step in your process. Bob is a partner in our DC office and provides representation for both underwriters and insured in the DC metro area. And Melissa Clark is in my office in Princeton. And while her primary assignment is to our environmental practice, she also provides defense for claims and coverage within New York and New Jersey. Then we will have Zach Burke and Indira Sharma covering our mortgage fraud claims topics. Zach is a partner in our Boston, Massachusetts office. He is a litigator by practice, and as many of you know, he provides insureds and underwriters with counsel in Massachusetts and Rhode Island, Connecticut, and some other of the New England states. Indira is in our Baltimore, Maryland office, also a litigator, and provides insureds and underwriters with counsel in the Maryland, DC, and Delaware area. And we'll also have, third is Steve Applebaum, and he's going to go over the very important issues revolving around equitable subrogation. Stephen is also in our title insurance litigation group, and he is in our Miami office and provides counsel to underwriters and insureds throughout Florida. And last, Matt Har and I are going to cover the ethical issues related to the interaction between claims counsel or claims managers and insureds and outside counsel. Matt is in our Harrisburg office and provides his services to underwriters and insureds throughout Pennsylvania, primarily in the Western District and the Middle District of Pennsylvania. And he's been handling these type of claims almost as long as I have. If during our presentations you have a question, and please feel free to ask us questions, you will see a Q&A box at the bottom of your screen. You can post those questions either generally or about the presentation that is being given, and we will look at those, and if time permits, we'll either try to provide answers to those questions right after the presentation, the given presentation, or at the end, again, if time permits. And if time does not permit, then we will try to follow up with you afterwards. You'll see on your screen now that all of our contact information is there, and feel free to contact us after the presentation if you have any further questions. This is a CLE, and so during the presentation, you will see 3 numbers. We will make sure that we highlight those for you, and you need to keep track of those, because at the end of the presentation, you'll be provided with a questionnaire. It'll be sent to you by email. You'll need to fill in those 3 numbers and then submit that questionnaire back to us. If in fact, and I can't remember exactly, but it may be that it's not us who submits, but rather you, but we'll make sure that you understand that and get your CLEs, which are obviously very important. Also, this presentation can be obtained through handouts, which if you would like, we can send to you after the presentation. And just remember, I have to say this, none of what we're providing to you here is legal advice that you would get from us if you engaged us. We're happy for you to engage us after this. If you have any questions or you have claims or coverage disputes that you need counsel on, obviously feel free to reach out to us. So we will now begin with Melissa Clark and Bob Gill addressing some of the new title claims and what's been the same. And so take it away, Bob and Melissa.
Good morning. This is Bob Gill. Thank you, Tripp, for the introduction. And what I'd like to do is to jump right in and start talking about the policy language and the framework for the policy. And we have somebody who is going to be putting up a slide deck. And let's go ahead and start. Here we go, the general background. So this just takes a minute to cover this, but the ALTA policies, both the owner's policy and the loan policies, they're not all risk policies. These are policies that limit the types of claims and risks that are covered by the policy, and they are defined as covered risks. Obviously, the policies also specifically exclude certain matters that are not covered, and those are defined as exclusions. And we're going to be spending a lot of time during this presentation talking about the exclusion issues, because that's something that we regularly deal with in the course of our defense of both insurers and insureds. Next slide, please. So the first CLE code is 13572. Make note of this code for those of you who need to submit a form for approval in your jurisdiction. The first code is 13572. If I could move to the next slide, page 4. All right, the exclusions from coverage are defined in the sections of the policy that address a host of exclusions. Exclusion number 1 is a group of laws, ordinances, or regulations that restrict or relate to the use or occupancy of land. Obviously, the insured does not want to insure somebody's local compliance with zoning regulations. With regard to subsection 2, character, dimensions, location of any improvements, relates to setback requirements, whether somebody has left a suitable apron or buffer between their property and the adjacent property. Subdivision 3 is subdivision of land. Obviously, the insured does not want to insure the requirements for subdivision of land. And then number 4, environmental remediation or protection. Let's go to the next slide, number 5. All right. Eminent domain is obviously not a covered risk. That's an exclusion from coverage. Number 3 is a big one. Any defect, lien, encumbrance, or adverse claim that is created, assumed, or agreed to by the insured. That's a standard exclusion from coverage, not just in the form ALTA policies, but for insurance policies generally. That's why indemnity provisions are so highly negotiated, because nearly every insurance policy is going to exclude from coverage liability which is voluntarily assumed. And that's exactly what exclusion number 3A does. Number 3B excludes information that is not known to the insurer. Later in 3B, it says that the disclosure must be made in writing to the insurer by the insured claimant prior to the date that the insured claimant becomes an insured under the policy. It specifically excludes information that's recorded in the land records, and therefore excludes constructive notice based on what's recorded in the land records. we'll talk about this a little bit later. There's a little bit, I think, of an ambiguity based on other language in the policy relating to this issue of knowledge. Exclusion 3C is a big one, which is a loss which results in no loss or damage to the insured claimant. This is something that I have seen on a number of occasions. I think in my experience, it's more frequently come up in the context of loan policies, where there is a loan policy, there's not an owner's policy, the property is sold, the consideration that's paid for the sale or transfer of the property is sufficient to cover the mortgage, which should mean there's no loss. But sometimes when the owner doesn't receive the value that they think the property is worth, and they're claiming that there is some defect with respect to the property and its title, then I've seen claims that have been made. And we have defended against these claims based on 3C, based on the fact that there's been no damage to the claimant. We've got a couple of authorities that are cited in 3C here that stand for this proposition. These are cases that involve loan policies and not owner's policies. Based on our experience, that this is an area where these claims are most likely to occur. I had one case, the one I was just talking about, where mortgage was paid in full upon the sale of the property, but the owner of the property when it sold the property, didn't obtain the consideration that it thought it should have been able to obtain for the property, and it brought a claim against the company. And we filed a answer to the complaint. We attached to the answer a number of documents that we planned on relying on for our defense, and then filed a motion for judgment on the pleadings. And I'm before the court arguing the motion for judgment on the pleadings on the issue of no loss or damage to the insured. And the judge looked at me and said, well, if the mortgage was $300,000, it was paid in full, the property was really worth $700,000, but was only sold for $500,000. Isn't that still a loss? And isn't it still covered by the policy? And the answer to the question I thought was clear from the policy language, which is no, it's not a covered loss, because it must be a loss based on the mortgage itself, not based on the profitability of the property, based on other expected gains that were anticipated. Is based solely with respect to the mortgage on the property. Next slide, please. Exclusion 3E, damage which would not have been sustained if consideration sufficient to qualify the insured named in Schedule A as a bona fide purchaser. This is a big issue. This is also a point that's covered elsewhere with other policy language as well. What they're getting at here, obviously, is whether or not this could be a fraudulent conveyance. Fraudulent conveyance is separately addressed in the exclusions from coverage, but the point is here, if fair consideration has not been paid for the transfer, then if any loss, including litigation that results from the failure to pay sufficient consideration for the property, is excluded from coverage. And we've seen this come up in a number of different contexts. Obviously, we've seen claims where garden variety fraudulent conveyance claims are brought. There's been some sort of transfer of property between related entities, and there is a question that's been raised by one of the entities that fair value wasn't given, and therefore when the property was sold, there was effectively a loss. That is not something that is covered under the policies. Exclusion number 4, unenforceability of the lien of the insured mortgage because of the inability or failure of the insured to comply with applicable doing business law. Classic example here, the insured is an entity, the insured is not in good standing, and the insured ends up being potentially invalidated by whatever jurisdiction where it was created. Obviously, that's an invalidity that's not going to be covered by the policy. If the insured cures the problem, the entity is not in good standing and it's brought into good standing, then this is something that should be curable, and it's typically curable for a long period of time. Next slide, please. All right. Exclusion 5 is something that it overlaps with a few of the other exclusions, and this concerns invalidity or unenforceability of the lien of a mortgage that arises out of a transaction that is basically prohibited or deemed actionable under usury law or consumer protection law. Usury law claims are fairly rare. Consumer protection claim laws, on the other hand, those claims are fairly common. That's particularly true here in DC. The DC Consumer Protection Act is extremely broad, and it prohibits a lot of conduct, and it provides for liability even in circumstances where the consumer hasn't suffered an actual loss. So there's strict liability for some violations. So, that is one of the statutes that is basically excluded by virtue of exclusion number 5. Exclusion 6, any claim by reason of operation of federal bankruptcy, state insolvency, or similar creditors' rights laws that the transaction or lien created by the mortgage is, for example, a fraudulent conveyance or fraudulent transfer. And so this is the provision that I was mentioning a few minutes ago that is somewhat duplicative of exclusion 3E, which talks about the sufficiency of consideration. This is broader than 3E because it concerns federal bankruptcy laws, state laws, whether or not a sufficient new value was given in exchange for the conveyance. Other issues that are implicated by this, and this definitely implicates other issues under federal bankruptcy law, which is something that we see from time to time. I've had a recent case on this, and under those circumstances, the insured acquired title to the property at the time when the grantor of the property was a debtor in bankruptcy. The agency that did the closing and provided the title commitment and issued the title policy didn't apparently run a check to determine if the grantor was in bankruptcy. So at the time of the conveyance, the grantor technically did not own title to the property. Obviously, a huge problem. That was something that ended up being cured down the road. The grantor of the property ended up being sued by a trustee in bankruptcy to invalidate the transaction. The matter ended up being settled, and then the insured comes to the carrier and is looking for the carrier to pay the settlement amount after the settlement has already been agreed to, which is a separate exclusion that we'll get to in a minute. But the federal bankruptcy exclusion under 6 is implicated in a number of different ways, not just a fraudulent conveyance or transfer, but to the extent that a grantor fails to obtain appropriate approval for the conveyance of property that where the grantor is in bankruptcy, that would be triggered by this too. And the general rule of thumb is when the grantor is in bankruptcy, the grantor is incapable of conveying title to real property. At that point, the real property belongs to the debtor's estate in bankruptcy, and the trustee and the bankruptcy court must approve any transfer of the property, and there must be a court order that's obtained in order to approve the sale or transfer. If there is no court order approving the transfer won't be valid. It's theoretically possible to go back and obtain an order from the bankruptcy court after the conveyance that ratifies a prior sale, as long as the bankruptcy remains pending. After that, you kind of lose ability to go back and try to cure the problem. That could trigger one of the other exclusions under the policy about whether or not this is a settlement and whether or not the carrier would need to consent to the settlement. which was something that we had some experience with, where there was a claim that was brought by a bankruptcy trustee. Bankruptcy trustee obtained a court order that invalidated the conveyance, which technically wasn't required because the grantor didn't own title to the property at all because of the pendency of the bankruptcy. But the trustee obtained an order that invalidated the conveyance, and then the insured comes to the insured, to the carrier, and asks for the money to be paid in order to fund the settlement. The settlement had already been entered into, which triggered another exclusion under the policy. So coverage was denied on that basis and a number of other bases. This was a situation where adequate consideration had not been paid for the transfer as an initial matter. The purported transfer was from a grantor who was in bankruptcy, so the conveyance itself was invalid. And then the settlement was entered into in order to cure the problem, and the insured did not obtain, didn't even request approval from the carrier in advance of the settlement, certainly didn't obtain the consent of the carrier in advance of the settlement, and then comes after the fact and wants approval was denied, and the insured sues. We defended against that claim, and we prevailed on that defense in the trial court. The insured appealed. The matter is on appeal now. It's been fully briefed and argued. It has not been resolved on appeal, but the insured was unsuccessful in its claim based on these exclusions under the policy. Next slide, please. All right, number 8 is obviously a standard exclusion for real estate taxes or assessments imposed by a governmental entity or other authority. Real estate taxes that are not paid obviously result in a super priority lien against real estate. The priority of a tax lien can jump ahead of and in line such that it becomes prior to the lien of an insured deed of trust or mortgage. So obviously the priority of a tax lien would create a problem for the insured. But on the other hand, the obligation to pay real estate taxes is the obligation obviously of the insured alone. If the insured fails to pay the real estate taxes and there is a lien on the property as a consequence, that's not a covered risk. Obviously, if the real estate tax lien is not satisfied, after a period of time, the local jurisdiction can enforce its right to obtain the real estate taxes by selling the property at tax sale. The tax sale that results from the tax lien obviously would not also be a covered risk. It would be an excluded risk under exclusion number 8, but it's really the super priority lien of the real estate taxes that triggers the need for this exclusion. There is a comparable risk. This exclusion talks about real estate taxes or assessments. It doesn't expressly address assessments that are imposed under a condominium regime, but those assessments present a similar risk. In the District of Columbia, the failure of a condominium unit owner to pay condominium assessments that have been assessed against the property by the governing condominium association have the ability to be a super priority lien under the DC Condominium Act. So the unpaid condominium assessments in DC present the same risk as unpaid real estate taxes in that they are liens that didn't exist at the time the insured takes title. They don't exist at the time that any purchase money mortgage is obtained on the property. Obviously, the lender for the purchase money mortgage is unaware of any such lien that doesn't exist. The lien is then created later in time based on the failure to pay real estate taxes or the failure to pay assessments from a condominium association. And those failures to pay those taxes or those assessments results in a super priority lien. Both super priority liens present a risk of a foreclosure sale in order to enforce the liens. Those are all not covered risks. Exclusion number 9 is any discrepancy in the quantity of the area, square footage, or acreage of land. Obviously, if the insured signs a contract to acquire a piece of property and it's alleged to be a certain area of land, after the insured takes title, the insured has a survey done and determines that what they thought they were buying in terms of total value or area of land is not what they ended up being conveyed. They can't bring a claim based on this exclusion 9. The documents which convey title to the insured and which create any insured lien on the property obviously will contain a description of the land, will specifically describe the land. In this regard, the insured knows what the insured is buying. The insured has an opportunity to go look at the land, to walk the land, to have a survey done. And if they discover a discrepancy later, that doesn't provide a basis for the insured to make a claim. The insured always has the ability to obtain a survey in connection with their purchase of the land. Another condition that we always like to see in connection with a acquisition of land is any information or defect that a survey would disclose. It's fairly common for that to be excluded if there was a recent survey. For example, if there was a survey in connection with the most recent sale transaction involving the property, then that's frequently a condition that is sometimes eliminated. We like to see that condition remain because frequently, if there is a problem, the survey will disclose it, and then there will be actual knowledge of whatever the issue is. And it could be a defect that relates to the square footage or area of the land. It could relate to an encroachment on the land. It could relate to some other claim which otherwise would not be known, but would be learned about in the context of performing the survey.
And Bob, this Tripp, just to sort of add some color to that. What this is distinguishing from is the metes and bounds of the land. So title insurance, covers title. And so certainly it covers if the metes and bounds are wrong, but when it comes to acreage or the quality of the land, whether it's sloped or not sloped, square footage, that is not a title issue. That's perhaps a valuation issue. It's a use issue, but it doesn't go to whether there is clear title or not. So I just wanted to draw that distinction for the audience.
No, that's exactly right. But at the end of the day, this is something that is within the grasp of the insured to determine at the time they contract to acquire the property or in connection with any kind of closing that's going to be conducted on the property. And basically, it's a consequence of their failure to perform due diligence. And if they later learn of some problem, then this exclusion keeps that from being our problem. That's the purpose behind that. Next slide, please. And so, in addition to the exclusions from coverage, there are a number of conditions of coverage. There's some overlap. Obviously, the contract of insurance identifies who the insured is under the policy. And all of our local jurisdictions here in Washington, D.C., in the state of Virginia, and the state of Maryland, all look to traditional principles of contract interpretation to interpret an insurance policy, meaning that unless there's an ambiguity in the language of the policy, the court is going to construe the policy based on the four corners of the document, looking at the language that was used. Only if there's an ambiguity can the court properly consider some sort of extrinsic evidence in terms of interpretation of the policy. you would think that it is self-evident that the only person or entity that could bring a claim on an insurance policy is the person who's defined as the insured claimant. But, just like lawyers are the folks who see business deals that go south, we're also the ones that see wacky litigation. So we have defended against litigation where claims were made not just by an insured under a policy, but based on some affiliate entity who was not defined as an insured. And sometimes that's important. So the case I'm thinking about is one where there was an insured mortgage, and so there was a claim made on a loan policy, and we addressed the claim based on the loan policy. But we also got a claim not by the insured. We got a claim from an affiliate entity that essentially asserted a claim that would be proper if made against an owner's policy. There were two problems. There was no owner's policy. And the second problem was the claim wasn't brought by an insured, it was brought by this affiliate entity. So there were two fundamental problems with regard to that claim. And basically the claim was there were defects with regard to the property. We'll leave out for now the fact that those defects were essentially self-inflicted on the part of the insured claimant. But they were alleging that when they sold the property, they didn't obtain the value for the property that the property should have produced, and therefore they had suffered a loss. And they asserted this loss claim with respect to the affiliate entity who wasn't an insured claimant. So we, of course, when we filed, this is kind of one of my standard strategies for responding to litigation wherever possible. I try to not respond with a 12B6 motion to dismiss in response to a complaint for several reasons. One is governing law essentially requires that even if I'm successful in a 12B6 motion, that the plaintiff be given an opportunity to amend if the defect is potentially curable. The reality is, the plaintiff is almost always going to be given a chance to amend. They may be given more than one chance to amend. So I prefer to not spend the time and money on a 12B6 motion if I can help it, and to spend my time and money on other issues. So if I can file an answer to the complaint and include with my answer relevant documents that are going to help support substantial defenses, then I will do that. And then shortly after filing the answer, where we've attached all these extraneous documents to support our defenses, as long as there's no motion to strike any of those documents that are appended to the answer, and I have yet to receive a motion to strike in response to that, we'll then come in and move for judgment on the pleadings. And a motion for judgment on the pleadings was exactly how we were able to reach the claim that was brought by this affiliate entity that was not an insured claimant. And therefore, the definition of terms under Section 1 was a part of the policy that we relied on for the motion. The motion was granted, as it should have been. But it didn't stop this affiliate entity and the insured from trying that in the first instance. Definition of terms with regard to knowledge or known. This is described to be actual knowledge or actual notice, and not constructive notice from what's in the land records. Now, to me, there's a little bit of an ambiguity based on this definition and the exclusion number 3B. Just to refresh your recollection for 3B, the exclusion under 3B was any defect, lien, encumbrance, adverse claim, or other matter that's not known to the insurer, not recorded in the public records. So that's the language that I'm talking about, because this expressly excludes information that would be disclosed by the public records, yet exclusion 3B to me presents the ambiguity, because it suggests that if a disclosure is made in the public records, then that would be sufficient. But it's something that's known to the insured claimant and not disclosed in writing to the insurer. So, this is obviously a big issue. In terms of defending these claims, frequently these defects are known to the insured, but the issue of knowledge is something that is, a very factual specific inquiry. So you're not going to be able to reach that on a motion to dismiss. That's going to be something that ultimately is going to have to end up being a triable issue. Sometimes you can rely on knowledge that has been specifically discussed in correspondence with respect to a claim made by the insured, and you can rely on that. But in the absence of that, this is a pure factual issue. It's going to be difficult to resolve on a motion for judgment on the pleadings. It's going to be difficult to resolve on a motion for summary judgment unless you're able to document this with deposition testimony, and it's going to end up being a trial issue. Next slide, please. This just bears brief mentioning. Obviously, the insured is obligated to provide written notice of a claim in accordance with a policy. If the insured fails to give written notice, then that's a defense. This policy writes in some of our local law on determination of failure to give notice, and that is there prejudice that results from the failure to give notice? The policy resolves that by expressly incorporating a prejudice requirement. So unless the carrier can show that it has somehow been prejudiced by the insured's failure to give notice, then you can't rely on the failure to give notice in order to deny coverage, at least not effectively. Next slide, please. Now, condition 5 is defense and prosecution of actions. A lot of this is fairly self-evident. Obviously, if the insured makes a claim and it's a valid claim, and even if there's a question about the validity of the claim, if it's a third-party claim, the carrier needs to provide a defense. The carrier gets to select counsel. The one point that I really wanted to discuss, though, is, and just for organizational purposes, I'm going to start tapering down my section of the of this discussion in deference to my colleague, Melissa. But this is one of the last points I wanted to really press. The insured has a right under condition 5B to, at its own cost and expense, to initiate and prosecute an action to establish title in the insured. And this is something that I have experience with as well. So, the case that I'm thinking about was a situation where the insured had acquired title to property. There were a lot of successive conveyances of the property in a short period of time. And with each conveyance, the value supposedly of the property increased considerably. So next thing you know, we were looking at a valuation that was sufficient to make this a major claim. Property was in Washington, D.C., but if you went and actually looked at the property, it was a vacant property. It was literally a crack house. And there was a multi-million-dollar claim made by the insured that they wanted to be compensated based on a failure of title. And there's no question it was a complete failure of title. It was a fraudulent situation where there's a fraudulent deed. There was fraud in the chain of title. There was no valid conveyance of title whatsoever. The circumstances of this were such that the claims counsel that I was dealing with for the insurer said, I don't like the smell of this claim. This doesn't seem right to me. I don't want to stroke a big check and put it in insured's property and reward them for behavior that, while I may not be able to prove that this was something that was illegal or unjust, it just doesn't sit right with me. So we took action to establish title in the insured. This was a property that, again, the deed was fraudulent, so it conveyed nothing. We looked at the chain of title to the property. The property had been owned by as of record by one person for a long period of time. The person was deceased. That person's sons and daughters were deceased. So we were looking at property that was then owned by all the grandchildren of the original owner. And we were able to go to a number of these heirs and negotiate and obtain deeds of conveyance of fractional interest in the property. We weren't able to obtain the entirety of the title to the property, but it gave us enough to go into court, and we then filed a petition with the court for the sale of the property, petition and sale, and we're able to use that as a vehicle to establish title to the insured. Meanwhile, the insured brought a claim against the carrier. There was an arbitration clause in the policy. We were able to take that claim to arbitration and show the arbitrator that we were exercising our rights under this section of the policy because we were taking steps to establish title to the insured. The arbitrator agreed, and we were successful in our defense of the claim. I'm going to wrap up my section of this discussion with just a couple more comments. The limits of liability under the policy obviously depends on the nature of the policy. If it's a lender's policy, the limit of liability is whatever the amount of the insured mortgage is, whatever the actual loss is on the mortgage that the insured has suffered. With an owner's policy, it's a little more amorphous because it's going to be the lower of the face amount of the policy or the value of the property. And the policy is good about defining what the time period is where you determine the value of the property. You're looking at it at the time of the initial conveyance. But that's always going to be a factual dispute. And so it's going to be something you really are not going to be able to reach on an initial motion. It's really going to be a trial issue, and it's going to require expert testimony on the issue of value. So with that, I'm going to power down my section of this discussion in deference to my colleague. I'm certainly happy to field any questions. There are certainly more to discuss about this, and I'm happy to field offline any questions you may have as well. Thank you very much.
Thank you, Bob, and good morning, everyone. Maddie, if we could jump to the slide, we're going to skip quite a few and jump to the one that starts with Jericho State Capitol. While we get there, I'm going to briefly discuss a few cases involving policy coverage and policy exclusions. Excuse me, back one, please, thanks. That arose in the in the last few years. So first up, we have Jericho State Capitol Corp versus Florida versus Chicago Title. This is a South Carolina case decided by the South Carolina Court of Appeals, which is the state's intermediate appellate court. This case arose out of an eminent domain action. South Carolina law allows counties and municipalities to establish official maps to reserve future locations of a street, highway, or public utility right-of-way, among other things. In the Jericho case, such an official map was created by way of ordinance to show the location of existing or proposed public streets, highways, and utility rights-of-way, public building sites, and public open spaces. The official map was amended by way of subsequent ordinance, and it was appended to the ordinances were a roadway map and an index map, and both ordinances were recorded with the Register of Deeds and indexed under the county, meaning not under the names of the owners of the land parcels in question. So what happened? Ultimately, of course, the South Carolina Department of Transportation filed an eminent domain action to take around 10 acres of a 130-acre development parcel for a new roadway. There was a condemnation litigation and an award of just compensation for the taking. In addition to all of that litigation, a claim was made against the policy issued by Chicago, which was denied. Bob laid our framework, of course, under the exclusion for ordinances relating to the use of the land, for the exclusion for defects, liens, encumbrances, adverse claims, or other matters subsequent to the date of the policy, and for the exclusion for condemnations. And so the insureds filed suit in response to the denial of coverage. The issue posed on appeal was, of course, whether a reservation of a right-of-way on an official county map constitutes a defect in or an encumbrance upon the title to the affected land or renders its title unmarketable so as to fall within the coverage of title insurance policies. Based upon the specific circumstances of this case, the court held the reservation of a right-of-way did, and none of the policy's coverage exclusions applied. More specifically, the court agreed with the insureds that the ordinance caused a defect in or encumbrance on the title because it created a third-party interest in the property in favor of the county, which burdened the land and depreciated its value. The court further concluded the ordinance created a reasonable probability of litigation concerning title because the right-of-way was reserved for acquisition, making future condemnation reasonably probable. On the bright side in all of this, the court did not find any bad faith by the insurer because there was a reasonable basis for denying the claims. It appears a petition for certification was denied in June 2022. So this is it on the Jericho State case. So for me, and I'm sure for many others, this case raises a lot of questions about title searching and exclusions and duties for closing real estate attorneys. I would encourage everybody to take a look at this case. If you need a copy, happy to provide it. In addition to, everything I just talked about, there are some interesting maxims and folksy expressions that perhaps make it a worthwhile read. So next slide, please. Okay, so I have two more cases to mention briefly. The first is Collum versus Cox. This is a good old-fashioned neighbor dispute. It's about the use and location of an easement in Wisconsin. Collum sued their neighbors, the Coxes, for interference with an easement. The Coxes tendered their defense of the claim to their title insurer, which was WFG, which denied the claim. The Coxes then filed a third-party complaint against WFG. But here's where it gets a little interesting. WFG issued the title insurance commitment in 2017. About 13 days before the Coxes recorded their deed. But through some error, WFG didn't actually issue the policy until 2020, several months after the Coxes filed their third-party complaint. The court went through a discussion of the effects and purposes of title policy versus the commitment and ultimately concluded the commitment was an offer to issue the policy the Coxes actually received, containing the very exceptions that WFG now relied upon to accept coverage. And so the court rejected the argument that because the Coxes didn't timely receive the policy, they were unaware that their contract accepted coverage for disputes relating to the easement. Of course, said the court, the insurer can't add additional exceptions to a policy that are not in the commitment, but that was not this case. Next slide, please. Salas case. In the interest of time, I will say that this is a model standard exclusion 3A case. So essentially a trustee executed a purchase agreement requiring the trust to build on the lot within 2 years after closing or face certain consequences, including the ability for the developer seller to repurchase the property and or obtain significant liquidated damages. The trust did not build on the lot within the 2-year period. Guess what happened next? The developer sued for a breach. The trust tendered a claim, which was denied. The coverage lawsuit was filed, and the court noted this exclusion, standard exclusion 3A, for defects, liens, encumbrances, adverse claims, or other matters created, suffered, assumed, or agreed by the insured claimant. The court said it's one of the most litigated clauses in a standard title insurance policy, and it's been described as excluding matters that are the insured's own darn fault. Next slide, please. I just wanted to switch gears quickly. As an environmental attorney, I would be remiss not to mention my favorite exception, which is tidelands claims, riparian grants. Tidelands, also known as riparian lands, are lands now or formerly flowed by mean high tide of a natural water body, including oceans, bays, tidal sections of rivers or creeks. Next slide, please. A claim is a cloud on title. So the state of New Jersey holds fee simple title to all lands now or formerly flowed by tidal waters. There are maps in the state of New Jersey that delineate these lands, and the seminal case is O'Neill versus the State Highway Department from 1967. basically said, doesn't matter the landowner has paid real estate taxes on the claimed land. Adverse possession does not run against the state, and the money that we collect from the sale of riparian lands will be used for the support of schools. Next slide, please. Finally, where might you see these pop up? Schedule B, Part 1, exceptions from coverage. So this is a couple of different examples of riparian grants listed in the title commitment. Grants are essentially a deed for the state for the sale of formerly flowed tidelands. You see there the requirement that the grantee must have been the upland owner at the time the grant was obtained. Can't have a random riparian grant. It has to be tethered to the upland portion. You see there's mentions of licenses. These are short-term rentals for currently flowed tidelands. They're usually for bulkheads or utility projects, constructions of bridges or maintenance of bridges. And just a final note on this, the natural processes of accretion and avulsion, the natural changes of the coastline can actually impact the extent of the state's claim. So with that, I would like to open to questions, if any, very quickly, or we can pass the baton to Indira and Zach.
So this is Tripp again. I'm just going to add a little bit here, specifically about tidelands exclusions. For most of those on the call, you know, while we have offices throughout the country, we're primarily on the East Coast, but also in Chicago and Minnesota. And I'm thinking about the fact that, you know, while a river or a creek may not seem at first to be affected by the tidelands exclusions, you have to look at how those rivers and creeks are affected by the flow of tidelands. And so never think simply because you know it seems as if the land is simply on a river or creek that's not affected by tidelands. That is not necessarily true. If you look, especially in around the Massachusetts area and Rhode Island and Connecticut and all the way down the East Coast, and then even if you're looking in the Midwest that have lands that are adjacent to the Great Lakes, those have tidelands as well. So it's an important issue. And the other thing I wanted to address on before we move to the next presentation on fraud is a couple of things that I've encountered on coverage, and in particular, in an instance where there has been some sort of either defalcation or otherwise the lenders and the insured's mortgagees funds have disappeared. There has been a increased recognition in the court that 3E may apply here, where the mortgagee's funds were stolen before they got to the appropriate party that was supposed to be dispersed to. There is an argument made, and I've made it in Pennsylvania, I've made it in New York, that that's a failure of consideration. And while the mortgagee may have claims regarding, you know, fraud by an agent, and then we can start to deal with whether or not there's vicarious liability there. Is the agent really the agent of the underwriter? That has been recognized by the court as a failure of consideration, and has allowed the application of that exclusion. And secondly, I'd like to again address the issue of what is really being covered by the policy, and that is title related defects, nothing else. And in Pennsylvania and New Jersey and New York, and I know in other states, while courts eschew not providing coverage to insurers as a general matter, they have also recognized that what the underwriter is responsible for is what's in the policy. And so if the policy is that relates to title defects, it doesn't relate to the a negligence claim. And many times I've seen where the insured say, well, you didn't read the abstract correct, and this might be direct operations. You didn't read the abstract right, and that resulted in a certain issue with the policy, or you didn't close correctly. And again, I'm just talking about direct operations. Well, those aren't policy claims. And so to the extent that the lawsuit that's brought is for coverage under the policy and not a claim for, and that claim, the complaint doesn't include claims for a tort claim of some sort, then, you can use that general parameters and that we've seen in the courts that have established that the relationship between an underwriter and an insured is the policy. That defines the responsibilities, nothing else. And in particular, in both New Jersey, Pennsylvania, and New York, the courts require a very specific fact showing, objective showing, that the underwriter has taken on additional responsibilities outside the purview of this expressed policy language in order for them to find that, in fact, there was some relationship between the insured and the underwriter that could give rise to a tort claim. That is, and so those are important, I think, important aspects to think about when you're looking at coverage. Again, whether or not, in fact, it's a policy claim or something that's outside of the policy relationship that's exclusive to the underwriter and the insured. So with that, we can turn it over to Zach and Indira to talk about what we've seen recently. I think we all know that fraud, I can't even say fraud is on the increase. It's just always there. But certainly, depending on the market conditions, we may see some upticks in fraud, but Zach and Indira, why don't you take it away?
All right. Thank you, Trip, and good morning to everyone. Zach and I are happy to be here today presenting on the topic of mortgage fraud claims. We are going to start off today with a little bit of background information on mortgage fraud trends, some statistics regarding the jurisdictions with the highest risk of mortgage fraud, as well as some mortgage fraud offender stats before getting into litigation considerations and some cases that we are handling at our firm recently around mortgage fraud issues. And then, of course, if you have questions, please feel free to put that in the chat, and we would like to address those at the end of our presentation. Next slide, please. So according to this CoreLogic mortgage fraud report that has all kinds of wonderful statistics on mortgage fraud is actually on the rise, even with a slower real estate market and increasing interest rates in the past couple of years. Mortgage fraud increased in all areas of fraud except for undisclosed real estate debt fraud. Next slide. So here's some different types of frauds that we'll see in some of the case scenarios, much of which you're familiar with and is pretty much common sense, but we wanted to show that income fraud is increasing. That is the most common type of prevalence in terms of increasing fraud. It increased by about 27% from 2021 to 2022. And that just involves misrepresentations by the loan applicant about their source of income needed to qualify for a loan. Next slide. Property fraud is also increasing about the same, and that involves misrepresentations about the value of the property. So that's also trending upwards. Next, please. And identity fraud, just a smaller increase there, about 5%. And that's when the loan applicant alters their identity or creates a false identity or stolen identity to obtain a mortgage. Next slide. Transaction fraud has just a slight increase there, about 2% in the past year that has been reported and recorded. Next slide. And occupancy fraud is another type of fraud where the loan applicant misrepresents the intended use of the property, saying that it's a primary residence instead of secondary residence, and the use of the property is directly linked to underwriting guidelines and pricing, and that's increased just a little bit in the past year or so. And then finally, next slide, we have undisclosed real estate debt fraud. That's the only type of fraud where we've seen this decrease, and it's a pretty noticeable one, 12% decrease in the past year. I did try to look and see why that was the case when all other types of frauds were trending upwards. Was not really able to find anything specific to that, but it is just an interesting fact out there. The next slide, this is interesting because if you're in certain jurisdictions, you might want to know that there are certain states with higher risk of mortgage fraud and certain states where it is substantially increasing year over year. So here are the top 10 states with the highest risk of mortgage fraud. You'll see New York is at the top of the list, and that is increasing significantly. But Rhode Island coming in at 3, there is a substantial over 60% increase in mortgage fraud in the state of Rhode Island there. There are some states where it is decreasing. Nonetheless, they still made the top 10 list, and some jurisdictions like DC, we're seeing a decrease in that jurisdiction, as well as Nevada, a significant decrease in the last reporting year of 27% decrease, and some others there that you can take a look at, particularly if you are in those areas. Next slide. So this is just a visual for those who are visual learners of the same information, illustrating the states with the highest mortgage fraud. Next slide. So there's some interesting statistics about who the perpetrators are of mortgage fraud. Most of them are men. I think it's interesting. This one was really interesting that most of them, 83% about, have no prior criminal history. Which is interesting. But for purposes of litigation, when we're talking about the damages, I think the last bullet point is most interesting. You know, what are the losses that we're seeing in these cases? And you can see that, you know, over 13% of those situations involved losses greater than 3.5 million. So there are some significant mortgage fraud damages out there in certain situations. And then about 37% involve losses of $250,000 or less. The median loss in these mortgage fraud instances was around $371,000. So with that overlay of where we're going, it's important to us because with the prevalence of mortgage fraud and the increase in that, we will expect to see more litigation, certainly more disputes and more issues that we need to handle. And we need to be mindful of the areas where it might be more prevalent and increasing. So I'm going to pass it to Zach to start us off with some of the litigation considerations.
All right, thank you, Indira. So with that background, it seems inevitable that you will encounter mortgage fraud claims in one form or another, especially if you're dealing with my home state of Rhode Island. I don't know what's going on there, but we'll have to figure out what's going on because the 60% increase is pretty radical. So I'm just going to start talking about some of the common types of cases you'll see in the mortgage fraud context. And here's a list on this slide: theft, defalcation of closing funds. And I've seen that in a couple different contexts. You have certain situations, and I think this has been common for a while. You might see a closing agent, closing attorney who defalcates with closing funds, fails to pay off a senior lien, and then keeps the funds for him or herself. More recently, I've seen a rise in cases where third-party actors intervene in a closing and engage in some sort of wire fraud by posing as one of the closing attorneys or a real estate agent or something to that effect, providing wire funds so that money at the closing gets sent off to the wrong bank account, to a fraudulent bank account. Obviously, these types of claims will result in mortgage priority issues, and they may be hard to resolve in equity, and you might be out there seeking damages when these types of claims arise. Another type of claim is a misrepresentation of existing liens by a mortgagor, and that's pretty self-explanatory, but a mortgagor might claim that a property is completely unencumbered, that the mortgagee is getting a first lien on the property when in fact there's judgment liens, there's other prior existing mortgage liens on the property. Another type of case that you may encounter are a fraudulent seller case, when someone who doesn't own a property pretends that they are the owner, then sells to a third-party buyer, and ultimately there's a mortgage involved, and then there's a claim that the buyer actually didn't buy anything and that the transaction should be voided. I've also seen cases where there's a fraudulent buyer circumstance where, and I don't know if fraudulent buyer is the proper terminology, but the buyer is claiming that he or she did not sign the mortgage documents or was not involved in the transaction. Maybe their name was used as a straw, something to that effect. A corollary to that is the last bullet point on here, when a mortgagor disclaims mortgage obligations. Again, the mortgagor claims that the mortgage documents were fraudulently executed, or may claim that they didn't receive the closing funds and that they were diverted to somebody else by mistake. Next slide, please. So when you're confronted with these claims, there are several causes of action that you can obviously consider. And there are either equitable remedies or claims for monetary damages. Obviously, in the title insurance context, and when you have an insured mortgage, you want to see if you can put the mortgage back in place where everyone anticipated it would be. And that would implicate these equitable type claims. Reformation, for example, is a claim that should always be considered if there's something fraudulently done with the documents. And if fraud is a basis for reformation in most jurisdictions, as far as I'm aware, sometimes unilateral mistake can be a basis for reformation. So that's something that might be implicated. Similarly, declaratory judgments, you might be going to court to seek a declaratory judgment that a certain mortgage is valid, depending on what the dispute is. Equitable lien is something that you might consider under certain circumstances. I think we may have a case we're going to be discussing later where an equitable lien was one of the issues that was raised. And that in that context, it arose where a mortgagor claimed that their name wasn't on the document, or an alleged mortgagor claimed their name wasn't on the document, but they actually received all of the benefits of the mortgage and used the property and paid the mortgage. And that might be a circumstance where you seek an equitable lien. In addition, equitable subrogation, we have an entire section on that, so I'm not going to get into that in any detail right now. As far as claims for monetary damages, when you're dealing with fraud, it's very common that the mortgage that has been insured is simply not going to be enforceable for whatever reason. It may be void, it just may be in a junior position now such that there's not going to be any equity left in the property to collect damages. So you might be left with a claim for monetary damages. In those circumstances, you have your tort-based claims, negligence, fraud, misrepresentation. You may have a breach of contract claim. You might also have a conversion claim. And for those of you who haven't dealt with conversion in a while, if you think back to law school, conversion is simply really a theft claim of any personal property. There may be a breach of fiduciary duty claim implicated if the attorney, if a closing attorney is the one who commits the theft of the funds. Another thing to consider is, does the jurisdiction that this case resides in have some sort of unfair and deceptive trade practices statute that might be applicable under the circumstances, or that arguably could be applicable, because that can provide a lot of leverage. I know here in Massachusetts and in other jurisdictions, these statutes provide for multiple damages, attorney's fees, and things like that. So if you can assert one of those, it's obviously beneficial. The last bullet point on here is bona fide purchaser, or I guess in this case, it would be bona fide mortgagee defense. And obviously that's not a cause of action to consider, but that is a defense, and that might be a viable defense in some of these claims where there might have been a fraudulent transaction, but the mortgagee is actually an innocent party who came in, provided value, full value for the mortgage, and that may be a defense to some of these claims. Next slide, please. Now, fraud claims clearly present some unique challenges that might not be present in a typical title insurance case. Obviously, remedying the mortgage and title, as I mentioned previously, could be very difficult in these types of cases because if the mortgage is fraudulent and void, that's just simply not an option. So then you're stuck in a situation where the remedy is really collecting damages. And the second bullet point on here, and Indira is going to go into a little more depth on this, but collectability is always something that should be at the top of mind when you're trying to resolve a mortgage, a fraudulent mortgage claim. You don't want to be spending a lot of money litigating when the defendant might just not have any assets that are worth chasing. These types of cases also present unique issues where a witness might invoke the Fifth Amendment. There are often parallel criminal proceedings going on or investigations. So what do you do when the primary defendant is just not cooperating during discovery? One thing obviously to consider is sending out subpoenas to any third party that might have any relevant information. And we'll talk about that a little more later. These cases present issues regarding authenticity of documents and signatures. You'll want to consider early on, do you want a handwriting expert involved? Do you need a computer forensic expert? And these are experts that I don't typically see in title insurance cases, but in these types of cases, obviously that's something you're going to want to consider and try to get them involved early to help guide your strategy. You want to make sure that all necessary parties are involved. I think that goes with any title case, but with mortgage fraud cases as well. Obviously, you don't want to litigate a case and end up in a situation where one party who has an interest was not involved, and therefore you have to relitigate some of the issues in a subsequent suit. Coordinating with prosecutors is a unique challenge presented by mortgage fraud cases. Oftentimes, prosecutors will not be willing to provide information. I don't think that's a surprise to anybody when they have an ongoing case, an ongoing investigation, but they can be helpful. I found that they will be willing to sort of highlight evidence that maybe you should take a look at, and they might tell you that without saying it explicitly, but they might help you there. In addition, I think it's also good where you could be helpful to the prosecutor, because then down the road, when their case is resolved, they might get a restitution award that can satisfy whatever damages are owed to the under the insured mortgage. And if you're helpful to them, that might be something that comes to fruition. Another thing I just wanted to mention is with closing protection letters, oftentimes there's a 1-year statute of limitations or claims limitation on a closing protection letter. So that's just something to keep in mind. If the fraud isn't discovered until a year after the closing, how do you get around that is an issue. Next slide, please. Now, as far as remedying mortgage title issues, this is something you really need to determine right at the outset of the case. Is the insured mortgage enforceable? Can the insured mortgage's intended priority be achieved? And you want to focus initial discovery on these questions to inform your strategy. Because if you find out quickly that there was a fraud here, this mortgage is not going to be enforceable in any respect, then you don't want to throw good money after bad, trying to, make the case that the mortgage should be enforceable. You really need to pivot at that point and focus your strategy on damages. And obviously that's something you'd like to learn sooner rather than later. Finally, I'll make the pitch that you want to record a lis pendens. Some jurisdictions require you to do that through a judicial proceeding, others don't. In any event, especially with mortgage fraud, it's a very good idea to do that as soon as possible, because you have no idea what the fraudster out there has done with other people, and you want your claim, want the public on notice of your claim as soon as possible to preserve your rights. Next slide, please. And I think I'm passing this one off to Indira.
All right, thank you, Zach. Speaking of not wanting to throw good money after bad money, we have to think as litigators, not only in mortgage fraud cases, but in all of our cases, we have to think about the likelihood of being able to collect on a monetary judgment and informing our strategy. And so, when monetary damages are the only available remedy, we need to think about if the borrower or the guarantors even have the assets that could satisfy the judgment. We also have to think about the fact that litigation is an incredibly lengthy process, and a lot of things can happen during the course of litigation. So we have to focus on pre-judgment remedies that might be available to help secure a potential judgment. And in some jurisdictions, Zach was mentioning in Massachusetts being one example, you can file to obtain a trustee process attachment. And the standard there doesn't require you to prove irreparable harm. You simply have to establish a likelihood of success on the merits. And if you obtain such an attachment, you can attach real estate and bank accounts to preserve the assets during the course of the litigation. Another tool to use pre-judgment might be seeking a preliminary injunction, assuming you can satisfy the high standards of proving irreparable harm and likelihood of success on the merits as well, to maintain the status quo. And that could be with respect to ensuring that real property is not sold, or simply that the borrower is not spending assets and moving assets during the course of the litigation, except for normal living expenses. So a couple of strategies there to ensure that you're going to be able to collect later on. Next slide, please. So this is something that we wrestle with at the beginning, and it is worth thinking about before jumping into filing a complaint. But at the same time, speed is incredibly important. Now, you do have to move quickly on some matters, but with respect to collectability, it's really important to do some preliminary research on the defendant to see if they even have the assets to satisfy the judgment. And you can do that through public records for real estate, obviously, but there's also a people map search on Westlaw, something that we have used and we use routinely to find out if our defendant owns substantial real estate or other assets. You can also find out information about their bankruptcy filings, criminal history, history of lawsuits, and other judgments that they might have against them, which is critically important in this case, because if they have a ton of judgments against them already and your judgment is coming in later, they might not have the assets to satisfy what you're looking for in a case involving monetary damages. Also important in these mortgage fraud cases is whether they have other judgment creditors. If they are frequent fraudsters, they have done this to many people, they have defaulted on other obligations, and there are other judgments already against them, you would want to know that, because that's critically important in assessing whether you want to go after them personally. And we're dealing with that now in one of our cases where we have an insured lender suffering over $4 million in losses arising out of a refinancing transaction due to fraudulent scheme by the borrower. And possibly a closing agent or a law firm that received funds as well. And not only were the deeds not recorded to put the insured lender in first priority as it should have been, but the closing agent and or law firm, they directed the closing funds in a way that was not instructed, and they did not follow the instructions. And that money was not used to pay off the prior loans, but instead used to pay off other creditors to the detriment of the lender. And in our situation, this borrower actually filed for bankruptcy, and we used the bankruptcy proceeding as a way of learning some information through the discovery allowed in that proceeding. And what it ultimately turns out to be is that this borrower, as well as the guarantors, likely don't have the assets to satisfy the judgment. But there is obviously a closing agent involved here that has satisfied some of that through settlement, but we also need to go after other parties in order to make the litigation worthwhile, so to speak. So I will turn it back to Zach to talk about proving your case.
All right, thanks, Indira. So these are just some considerations issues that might come up when you're trying to prove a mortgage fraud case like this. As I mentioned previously, the defendant might plead the fifth or invoke what's known as the act of production doctrine. And if you haven't come across that before, the act of production doctrine is essentially, it's related to pleading the fifth. And it's a situation where a defendant will claim that they can't comply with written discovery requests and produce documents because the mere act of producing those documents will communicate or implicate, the criminal issues or have an implication on whether or not they're guilty in their criminal case. And I've come across that recently in a matter, and you might have to consider whether or not you should move to compel the production of those documents. The claim might be invalid for several reasons, but if someone makes that type of claim, it's good to know that it's not an LLC, a corporation cannot assert the act of production doctrine. So if the defendant isn't an individual, it might not implicate the act of production. On the other hand, if the defendant does make valid claims of the Fifth Amendment, which if they make the claim of the Fifth Amendment, there's really nothing you can do about it. But if they make a valid act of production doctrine claim, what do you do next? I've had a situation where the defendant simply wouldn't cooperate in discovery because of an ongoing criminal matter, wouldn't answer any questions at the deposition, pled the fifth, refused to produce documents. In that circumstance, number one, I would say send out subpoenas, try to get discovery from any other sources that may have relevant information. But you also should consider whether or not you can file a motion for default judgment as a sanction for failing to comply with discovery. And in this other case I had, we did that. The court entered a default judgment as a sanction for the defendant's failure to comply with discovery, and also entered judgment on our claim under the state unfair and deceptive trade practices statute. So we ended up getting the damages trebled plus attorney's fees, and we ended up with a judgment over $4 million. So that's something to consider in these cases. As I just mentioned, you also want to make sure you subpoena numerous sources, even if you think the documents might be duplicative that you're receiving from the parties. And this would include banks, mortgage companies, insurance brokers, employers, etc. Because obviously you might see discrepancies in what one bank has versus what another bank may have. And that might help you ferret out what documents are legitimate, what documents have been fraudulently produced. Next slide, please. Similar to that, you want to obviously depose all relevant parties. Not only will this help you get a full picture of the factual circumstances, but as with any litigation, the more witnesses you have, the more likely the defendant's case will fall apart and you're going to get conflicting testimony from different people. I mentioned this previously. You want to get your experts involved early. Think about whether you need a handwriting expert, some computer forensic expert, some forensic accounting expert. They can not only, can they be helpful in assessing the strategy. They might be less expensive than attorneys doing that work, and probably given their expertise, they'd be more efficient and more effective at reviewing, counting issues, computer forensic type issues. And I mentioned this earlier as well. Make sure you have all necessary parties joined in the litigation so you don't have to relitigate these issues when you think you're done in the first instance. Now I'm going to turn it back over to Indira. We're just going to run through a couple of factual scenarios and cases that we've had in the past to give you an idea of what types of cases may come up and some takeaways from those cases.
All right, thank you, Zach. So our first case, and this is an active one, and with our cases, we don't mention usually the case or the client information, so they don't have case citations, but they are interesting because they're real ones that we've handled, and I think that they can illustrate some of the concepts that we have discussed so far today. So this first one is an ongoing litigation that we have where the insured lender lost first priority lien due to a delay in the recording of the mortgage. Now the mortgage, I believe it was executed in August of 2020, right in the middle of the COVID pandemic. And there were numerous administrative delays at that time with government and just getting everything recorded. So in this situation, the deed was not recorded until November. However, unbeknownst to this lender, the borrower had a judgment entered against him by confession just days after he signed the mortgage. And clearly the borrower knew this was coming. He was involved in this litigation and was expecting a judgment against him any day now. And so obviously that judgment took priority, and our insured lender suffered as a result of this delay in recording the deed. So what did we do? Well, there was a property foreclosure proceeding that was going on when there was a default on paying this mortgage. And we filed a motion to intervene in the sale of the property, arguing that the sale should be stayed. We filed a complaint in equity. This is a situation that screams of equity. And the complaint was in multiple counts. One was for declaratory judgment, arguing for equitable subrogation, something that we're going to do a whole presentation on next. Stephen Applebaum will cover that, so won't go into too much detail there. And then there was another count for equitable lien. Again, all of these being equitable remedies. The bank the bank, a party in this case, filed objections attempting to dismiss the complaint and was unsuccessful in doing so. So we were allowed to intervene and our complaint was filed. And the case is now in the discovery phase of litigation. So I think this case just illustrates the type of equitable reliefs that might be available and the importance of assessing your situation up front to see if you have grounds to intervene in the sale of a property, or whether you have a cause of action in equity, or whether it's for equitable subrogation or equitable lien. So next slide, please. So just very briefly, because Stephen will cover this in detail, you have to know if you're going to qualify for this equitable subrogation. And one of the key factors there is that, the subrogation will not cause injustice to the rights of others, that the claimant paid the creditor to protect his own interest, and also that the claimant was not at fault. Next slide. Courts of equity will not relieve a party from the consequences of their own error, whether it's, the lender's own error or the closing agent's error as well. And so that will not be a situation for equity. And what I think is key here is that, this delay was related to the COVID pandemic. And so the court steps in those situations and makes rulings based on fairness. Let's talk about the next one. I think the next slide is case number 2. So there are instances where there is fraud and negligence by a closing agent or a bank or, a law firm receiving funds, like I mentioned earlier. And those cases are different because the remedy sought there is monetary in nature. So this is a case, classic identity fraud, where someone impersonated the real owner of the property. The property at issue was a vacant lot, and this impersonator sold the property and absconded with the funds. So that's essentially what happened here. Interesting fact, the title search did reveal that the owner of the property at issue was actually different from the purported seller. And, it might have been confusing because it was just the last name and first name reversed. So I'm not, sure exactly what happened and how that error happened, but nonetheless, it was an error and the agent failed to disclose it prior to closing. So here's a situation where the first name is the last name and the last name is the first name, and it was flipped. And what happened is, perhaps because of that confusion, the bank also failed to recognize and should have recognized fraudulent activity when that fraudulent owner attempted to add his name to the bank account to gain access to the wired funds. So in this particular case, we were able to get a settlement with contributions from both the purchaser's bank as well as the title agent after they realized the facts were really stacked against them in that regard. Next slide, please. The settlement occurred after contentious litigation by the bank about whether it should be liable. But a key factor in this case was the discovery and what it revealed. We focused the discovery on obtaining facts that the bank should have known that there was fraudulent activity. And that's what was able to force the favorable settlement for our client. Let's talk about one more, and then I'll turn it over to Zach, and he can talk about his cases. So this is an interesting one. This is a case of forgery on the mortgage documents. We have a husband and wife situation. The husband either forged the wife's name, or the wife unknowingly signed a mortgage in 2007. The couple then divorced maybe a couple years later, and then there was a default on the mortgage. So what happened in this situation is the complaint was filed by the current holder of the mortgage. There were numerous assignments, and the complaint was for an equitable lien against the wife. We filed for summary judgment and won on summary judgment. And the opinion granting summary judgment laid out the reasoning for why an equitable lien in this situation was appropriate. The court reasoned that because both the husband and wife were unjustly enriched by having received the mortgage proceeds to pay off their various debts, that the wife should be deemed liable for this debt. And so there was another component to the opinion as well. Next slide, please. That was related to precedent in this Pennsylvania state court, saying that in situations where you have one spouse executing a refinance that satisfies a prior mortgage, unless the other spouse demonstrates the mortgage was obtained fraudulently or the refinance lender had unclean hands, the court will impose an equitable lien. So, it's a unique situation to know about with respect to husband and wives and kind of the standard that a court would apply in imposing this lien. Just a quick note about the terminology we've been using. We've been talking about equitable relief, equitable subrogation, equitable lien, and sometimes you'll see the term equitable mortgage. I think in practice, sometimes the terms are used interchangeably, even though there might be these fine line distinctions. I think of equitable subrogation as being a situation where there is a change in the status of one's priority that is being sought, moving, from a second priority, second lien position to a first lien position is typically what you're trying to seek with equitable subrogation. But nonetheless, they are all equitable types of relief. So Zach, I'll turn it back to you to talk about a couple more.
All right, thanks, Indira. So this fourth case that we're going to discuss relates to a situation I described earlier, where a real estate attorney had basically set up a pyramid type scheme where he would fail to pay off senior liens during refinancings and fail to get discharges of those senior liens when his clients refinance their properties. He was keeping the refinancing funds that were supposed to be paying off the senior lien, changing the borrower's address on the senior lien on the mortgage statements, and then having them sent to his office and then paying the monthly payments on those statements. When certain of his clients, years later would realize, hey, my first mortgage hadn't been paid off when I refinanced, they'd reached out to the attorney and he said, feigned that it was a mistake, said, oh, I'm really sorry. And then went on and did the same thing to his next client, took the funds to pay off the earlier client's senior lien. And this kept going on and on for years. Eventually, there were a couple lenders whose liens were not paid off, and there were title claims involved, or insured mortgage claims. In that case, the attorney was eventually caught and disbarred, and that was before any claim was made. Next slide, please. So we got involved, and what we did is really related to something that Indira mentioned earlier. We filed a verified complaint in this case, and we attached the findings from the bar proceeding where this attorney was disbarred. And in doing that, we made the case that we should obtain prejudgment security from the court. As Indira mentioned, in some jurisdictions like Massachusetts, that might not require a showing of irreparable harm. It just might require a showing of a likelihood of success. And The court found that we did have a likelihood of success based on the disbarment proceedings where the defendant had admitted some of the wrongdoing. So we ended up getting a trustee process attachment and real estate attachments against this attorney. Shortly thereafter, given the findings of a likelihood of success, the defendant entered into an agreed judgment with us rather than spend a lot of money on discovery litigating an issue where he was very likely to end up losing. Collectability, again, was an issue because this attorney had done this so many times, he had no money left over. So the benefit, though, however, of getting the judgment was it's good for 20 years. If there are any assets that are obtained in the future, that judgment could be used to collect, at least to some extent. And also, because of our strategy in this case, getting these attachments early on, the case itself, the litigation was pretty quick. So there wasn't a lot of time and money spent on litigating. Next slide, please.
Hey, Zach, this is Trip.
Yes.
I just want to interject. I just want to remind the attendees, this can actually, that scenario that you just gave, where it was an attorney, and maybe that attorney was the title agent, and maybe there was even a closing protection letter or closing servicing letter. And then all these lenders come to the underwriter and say, look, I don't have the title you insured. And it really does beg the question of whether or not there is coverage. And I just want to suggest to those who attended that the coverage issue isn't as easy as perhaps some think. It's not just, hey, you insured title, I don't have title, therefore, you have to go out and retain Saul Ewing and obviously the in terms of establishing title, it's not going to be that it's going to be hard given the acts of the agent or the attorney here. And really it's about having to pay off the original mortgage that was supposed to be paid off by the agent in the first place. And so you have to start litigation in order to try to find the money, right? It's really not a title issue anymore. It's really about engaging outside counsel to do all the things that Zach and Indira have talked about and try to get that money so that the first mortgage can be paid off and the insured can get into the position that it wants to be in or expects to be in. But before you get there, it is a question of coverage. And as I noted earlier, both in Pennsylvania and in New York, and I know New York does not have a closing protection letter in that state, Pennsylvania does recognize it. If that closing protection letter has expired, and so you're not obligated to do the things we're talking about because you've provided basically indemnity for these types of acts within the closing protection letter, it is a question of coverage. And as I noted before, something to think about is whether there's coverage here or whether it's covered, but there's an exclusion. And those exclusions are, at least, and I've litigated this in Pennsylvania, went all the way up to the state Supreme Court, and we prevailed there, is one, was there consideration paid for the insured mortgage? Supreme Court, we argued no under 3E, there was none. And by the way, it was the agent of the lender who caused this loss, caused consideration not to be paid. And so that's what the Supreme Court, and they agreed. And so there was no coverage in that action because of the exclusion. So I would just, commend those on the call and to talk about it some more in-house, after this presentation. In these situations, is there actually coverage? Obviously it's also a political question, little p political question as to whether or not you would want to take such a position with your clients, especially if it's happening frequently. And I think that there may be, in fact, an increase in this. I was involved in a case in New Jersey where it was the lender who was actually defalcating. And the way it was happening was the lender had a line of credit. and it had tons and tons and tons of refis as well as purchase mortgages, and it wasn't paying off, but rather taking some of the funds or some of the loan proceeds and then using subsequent loan proceeds to pay off earlier loans. Ultimately, as they say, the music stopped and someone was holding the bag. In this case, most if not all of the mortgages had been sold, not once, but twice into the secondary market. And so you had investors and trusts who held mortgages that they thought were first, but were actually second. And so there were coverage claims under that issue. And again, you have the question, is it covered or not covered? And if it's not, then it really it is covered, but you have a real problem establishing priority for your insured. Then you need to pivot and you need to stay involved in that litigation. I would not suggest just to simply go ahead and pay off all of those mortgages and then find yourself in a case where you're saying I'm subrogated to my insured's position and have to deal with that, or have it go to the recoupment department. I think that I would recommend you stay involved and basically serve and have counsel for those insured and try to seek as much proceeds or much money as you can so that you can later use it to either pay off the mortgages or reimburse yourself for paying off those mortgages.
Thanks, Tripp. Great points. And as Tripp said, while we're happy to get cases and litigate for you, obviously, if you can disclaim coverage and you have a strong coverage position that one of these claims is excluded, even better. So the next case that I was going to discuss, and I think this is the last sort of case scenario, is a situation where a family owned a very large, expensive oceanfront property, and the title to the property was held in trust, and the property was encumbered by a multi-million-dollar first mortgage. Eventually, one of the trust beneficiaries was in need of money, and he was also sort of the trustee of the trust as well. And what happened was he went ahead and recorded a fraudulent partial discharge of that first mortgage, which basically gave the impression that a guest house on this large oceanfront property was no longer encumbered by any liens. So then they went ahead and obtained two mortgages from different lenders who each thought they were going to be in first position on this portion of the property that was purportedly no longer unencumbered, and gave a different address for that portion of the property, and had actually conveyed that piece of the property to one of the other beneficiaries of this trust through an LLC, and then to the person individually. In any event, the mortgages that were eventually given for the property contained the wrong legal description for this parcel that had appeared, that was subject to this fraudulent partial discharge, but they had the wrong description of the property. So it was describing a different piece of land than what was supposed to be encumbered. So now you have a really big mess. Next slide, please. So we ended up in the case in order to file a reformation action just to fit the description. And that's what we thought at the outset that this case was. But then the defendant, who was the record title holder of the property and the borrower on the mortgages, claimed that she was not involved in the mortgage application process whatsoever and had not signed the mortgage documents. So now we're in a case which we thought was a simple reformation action. We thought there was a mistake in the description, and it's a full-blown fraud case. So what did we end up doing? First, we ended up getting a lis pendens to make sure that the property wasn't conveyed or encumbered with any future liens without our knowledge of our client's claim on record. And that was a good thing to do, because eventually the defendant here ended up giving another mortgage to an entity that was owned by a family member. But because of the lis pendens, the priority of our clients was maintained. We then proceeded to get discovery from numerous sources. So the party here who is sort of the ringleader of this scheme was being investigated by the FBI. Federal charges were brought against him, and he invoked the Fifth Amendment and refused to produce documents. We ended up getting a bunch of bank statements, tax returns, employment records, everything we could possibly get our hands on. And we ended up building the case that the defendant, who was claiming that she hadn't signed any of these documents, and that it was her family member, one of the other beneficiaries, who did all of this without her knowledge, even though she was the record title holder of the property. We built a record that she had provided all of these documents for the mortgage applications that could not have been provided but for her participation in this scheme at some level. So we built a circumstantial case that we didn't have any direct evidence of her participation, no admissions, but it was pretty clear, and we think it's pretty clear from all of those documents that were provided for the mortgage application that this individual knew what was going on and knew that there was an intent to take out a mortgage on the property. Now, as I mentioned, there was this criminal proceeding going on as well. So throughout this whole time, we were trying to coordinate with the prosecutor's office. And although they didn't want to give us much information, they were willing to highlight documents that they thought were helpful to our case, you know, with a wink and a nod, really saying, hey, take a look at this partial discharge or this aspect of it. That might be important, that kind of thing. So keeping an open line of communication was important with the prosecutor. Eventually that defendant in the criminal matter ended up pleading guilty, and we ended up giving a victim a witness impact statement at the sentencing on behalf of the lender clients, which the prosecutors really appreciated. We provided the prosecutors with a lot of information about the damages that they had suffered as a result of this fraud. And in doing so, the prosecutors pushed really hard and were able to get a restitution order from the court as part of the sentencing, in addition to the prison time, that if collected upon would make the lenders whole. So you don't always need to litigate the civil case to the end in order to, when you have a situation like this where there's a criminal proceeding going on, there's other avenues to try to recoup whatever money's out there to recoup. So I think the lesson there is take as much discovery as you can to help prove your case. And also, if there is a criminal situation as well, which often there is in these cases, work with the prosecutors because they might be able to help you recover something in the end. Next slide, please. Indira, I don't know where we are on time. I think we're actually butting up against time. So
yeah, and I think you adequately covered the point of the last two slides, which is there is a criminal component to this. We just thought we were going to end with this is a criminal case, but the point being that you should be aware that that is a parallel that's going on sometimes in these cases. And Zach adequately covered the coordination that's needed when there's criminal aspects of these issues as well. Let's go to the last slide though, because it has the CLE code on the second one that you all will want for your credit. So the CLE code is 24689, again, 24689. And with that, we have concluded our section of the presentation. I believe we're going to be taking a 10-minute break and returning back at 11 o'clock for equitable subrogation with Stephen Applebaum.
Great. Thanks, Zach. And thanks, Indira. Thanks for the earlier presenters. And yes, let's take a 10-minute break. We will begin promptly at 11 o'clock. Okay, we'll start in just under a minute. The section will be on equitable subrogation. And I just remind everyone, if you have any questions, whether about the specific topics being addressed or generally about coverage or issues with claims, you are here to answer those questions as well. So feel free to put those questions, comments, concerns into the Q&A, and we'll try to address them as best we can. Okay. It is now, at least according to my watch, around 11 o'clock. So I will turn it over to Stephen Applebaum.
Thanks, Trip, and good morning, everyone. So the topic that I will be discussing is equitable subrogation, and it's Indira and Zach were fortunate enough to give me a perfect lead-in. Equitable subrogation is an important arrow in our quiver, particularly when we're dealing with refinancing transactions gone awry or in mortgage fraud types of claims. And I think it's important that we first define the concept. So what is equitable subrogation? It is when a new lender that pays off an existing senior lien leapfrogs ahead of earlier recorded intervening liens. So put another way, the doctrine of equitable subrogation is an equitable remedy used to reorder the lien priorities so that the junior lien remains subordinate and in the position that they intended to be in, and the new lien obtains the priority position of the lien that it paid off. Next slide, please. This slide, I think, is a good illustration of the concept. And so walking through it from a timeline perspective, mortgage A, which was a $100,000 mortgage, was recorded on January 1st of 2022. 6 months later, mortgage B, which was in the principal amount of $50,000, was recorded on June 1st, 2022. Mortgage B, in all likelihood, was a second mortgage on the property or a home equity line of credit that was intended to be subordinate to that first mortgage that was recorded 6 months prior. Then 6 months after that, mortgage C comes along. It's in the same principal amount as mortgage A. It was recorded on December 1st, 2022, but the proceeds of mortgage C were used to pay off mortgage A. It was always intended to be in the shoes of the first position mortgage. And when equitable subrogation is exercised, it leapfrogs ahead, mortgage C leapfrogs ahead of mortgage B. Oftentimes in equitable subrogation cases, mortgage B forecloses on their interest in the property and takes the position that mortgage C, because it was recorded after mortgage B, should be subordinate to it. Mortgage C will take the position that equitable subrogation puts it into the shoes of the first position mortgage, and it is not subject to foreclosure by the subordinate mortgage. A lot of times in equitable subrogation cases, you see a case where a home equity line of credit is drawn down or not satisfied, and they foreclose on the subordinate liens that are recorded after, but really take the position of a first position lien because of the application of equitable subrogation. Next slide, please. This is the same situation that we talked about, but here mortgage C was in excess of the amount that was used to pay off mortgage A. And so you get into a situation where a portion of mortgage C may take the priority over mortgage B, but the $50,000 that was not used to pay off the mortgage A, but was used after the fact or was funded after the fact, may be subordinate, in fact, to mortgage B. And so then you get into an issue and contest as the priority of the funds and whether there can be a partition of the mortgage such that certain portion of the mortgage is prior to mortgage B because of the exercise of equitable subrogation. And then certain funds may fall after mortgage B when you're looking at a surplus type of analysis after a property is foreclosed. Next slide, please. In a lot of jurisdictions, you see reliance upon the case of Mort versus United States, which is a Ninth Circuit case that I think did a good job of explaining and defining the concept of equitable subrogation. And in that case, the court said that equitable subrogation is generally appropriate where, and it came up with 5 factors. 1, the subrogee made the payment to protect his or her own interest. 2, the subrogee did not act as a volunteer. 3, the subrogee was not primarily liable for the debt paid. 4, the subrogee paid off the entire encumbrance. And 5, subrogation would not work any injustice to the rights of the junior lien holder. And in that case, the court stated that equitable subrogation is a broad equitable remedy, and therefore it applies not only when these 5 factors are met, but also whenever one person not acting as a mere volunteer or intruder, pays a debt for which another is primarily liable, and which in equity and good conscience should have been discharged by the latter. The concept of whether a paying party is a volunteer or intruder has been discussed in a lot of the case law, and some states find reasons to label a lender as a volunteer, which can bar the application of equitable subrogation. In other jurisdictions, they follow the rule that a lender is not a volunteer if the lender intended to receive a first priority lien or paid the debt by agreement, which in most jurisdictions, equitable subrogation will be applied because the bank or the mortgage company that's paying off the first mortgage as part of the refinancing transaction will not be considered a volunteer. Next slide, please. The jurisprudence in this area has developed three general approaches. The first approach is that knowledge of the intervening lien is irrelevant. And here in Florida, that is the approach that's applied. And it follows the restatement third of property mortgages, section 7.6, which was developed in 1997. The majority view is that a party with actual knowledge of the intervening lien cannot seek equitable subrogation. And the minority view is that a party with either actual or constructive knowledge, so constructive knowledge being that the mortgage is recorded in the public records, it may not have been picked up on a title search, that party that has either actual or constructive knowledge of the intervening lien cannot seek equitable subrogation. Next slide, please. These equitable subrogation is often helpful and applied when you're looking at priority contests, and often come into play when you are applying the notice statutes. Are you in a jurisdiction with a race statute, a notice statute, a race notice statute? Because equitable subrogation will often be in derogation of these state statutes. And so this chart on the slide that's presented before you identifies some states that apply each of the three different approaches, with Florida applying the restatement where regardless of notice, whether it's actual or constructive, equitable subrogation will apply. And there's a case discussing, and I think doing a good job of capturing the essence of equitable subrogation, which I cited to. It's a Florida Supreme Court case from 1933, SunTrust Bank versus Riverside National Bank of Florida. And in that case, the Florida Supreme Court said, the doctrine of equitable subrogation is designed to apply where the claimant satisfied an obligation of another and then stands in the shoes of the satisfied creditor. The doctrine is founded on established principles of equity to prevent an unjust forfeiture on one hand and a windfall amounting to unjust enrichment on the other hand. The windfall concept that they're talking about is if equitable subrogation did not apply, then the party that was in second position, second position would be entitled to a first priority lien on the property and could foreclose out the refinancing lender, such that the refinancing lender would not take first position, would not get credit for the proceeds it used to pay off that first position, and a windfall would be realized by the intervening junior lien. Next slide, please. There are some cases throughout the country that talk about the interplay between equitable subrogation on one hand and title insurance on the other hand. And there's this conundrum that courts are grappling with, which is how do you reconcile putting a party in first position when title insurance should have uncovered this intervening junior lien, and the state statute sets forth, or the state recording statute sets forth, the order of priority in which liens should be recognized. And so I've identified a couple of cases here. The first case is out of New York, which is Roth versus Parash. And in that case, it's a 2001 case where the court said knowledge of title insurer bars the use of the equitable subrogation doctrine. That case was actually abrogated in a 2012 case called Arbor Commercial Mortgage versus Associates at the Palm LLC. The second case is out of Virginia. And in that case, again, equitable subrogation was denied because the title searcher for the new lender missed the intervening lien. The other case, the next case is out of Tennessee. Again, a negligent title search barred equitable subrogation. And the fourth case is out of Ohio. There, the court also found that equitable subrogation should be denied because the lender was negligent in not discovering the recorded intervening lien. And in the fifth and final case, which is out of Mississippi, it's a 2014 case. There, the court went into the policy reason for why they found that equitable subrogation should not be exercised when the title insurer failed to pick up the junior lien. In that case, the court said, other courts have found that the principles of equity required consideration of the negligence of a title insurance company, which bungled the transaction in the first place. After all, either they insure or they don't. It is not the province of the court to relieve a title insurance company of its contractual obligation. Next slide, please. This slide sets forth the restatement third of property that defines the concept of equitable subrogation, and that is adopted in Florida and a lot of other jurisdictions, and I think ultimately is slowly going to become the majority view in most states. And so in the restatement third of property, A, it says, one who fully performs an obligation of another, secured by a mortgagee, becomes by subrogation the owner of the obligation and the mortgage to the extent necessary to prevent unjust enrichment. Even though performance would otherwise discharge the obligation and the mortgage, they are preserved and the mortgage retains its priority in the hands of the subrogee. In other words, leapfrogging. So the last in time mortgage that is used to pay off or refinance the first mortgage will retain the priority of the mortgage that is paid off. Section B gives certain illustrations. It says, by way of illustration, subrogation is appropriate to prevent unjust enrichment if the person seeking subrogation performs the obligation, 1, in order to protect his or her interest, 2, under a legal duty to do so. That concept is the volunteer or intruder concept that we talked about earlier. 3, on account of misrepresentation, mistake, duress, undue influence, deceit, or other similar imposition. So here, this talks about the fraud examples or some of the fraud examples that were discussed earlier by Indira and Zach. And 4th, upon request from the obligor or the obligor's successor to do so, if the person performing was promised repayment and reasonably expected to receive a security interest in the real estate, with the priority of the mortgage being discharged. Here, in refinancing transactions, the refinancing lender is expecting to take the priority interest of the mortgage that it is paying off, hence the application of equitable subrogation. Next slide, please. The Washington Supreme Court in 2007 adopted equitable subrogation and adopted the concept in the restatement third, which is to say that knowledge, whether it's actual or constructive, is not a consideration when applying equitable subrogation. There, the Washington Supreme Court held that a refinancing lender should be entitled to assert the remedy of equitable subrogation in order to avoid a windfall to the intervening lien holder, even if the refinancing lender has both constructive notice and actual knowledge of the existence of the intervening lien. And that's the Bank of America case versus Presence Corp. This concept overrides state recording laws that give priority to earlier recorded liens. So a junior lien that is recorded, or an intervening junior lien that is recorded before the refinancing lender, will still take the junior position because of the exercise of equitable subrogation. Next slide, please. This slide discusses some of the policy considerations for why knowledge of the intervening lien is irrelevant. The refinancing lender is permitted to cut the line, meaning their mortgage is going to take priority over the junior mortgage. And that's intentional because the refinancing lender believed that their proceeds were being used to pay off the first mortgage and was intended to take priority over what was always intended as a second mortgage on the property or home equity line of credit that is subordinate to the first mortgage. Absent equitable subrogation, the intervening lien holder would receive an unearned windfall. When their mortgage was placed on the property, they expected to be junior. They expected to be subordinate to the first mortgage. And if equitable subrogation is not applied, they would, in essence, take first position and be able to foreclose out the refinancing lender. There's a policy consideration that some believe there will be customer savings on the cost of title insurance. If there wasn't equitable subrogation exercise, there could be a severe strain on the refinancing market if the intended priority order is not maintained or is disturbed because courts do not apply equitable subrogation, and that cost could be passed on to borrowers who are taking out title insurance. There's also this concept of a streamlined refinancing process. So even if the title insurer does not find a junior mortgage, or even if that junior mortgage is listed on the policy as an exception, there's this concept that equitable subrogation will be applied and refinancing mortgagees will be given the priority that they intended to be in through the refinancing process. Last, there's a lower risk of foreclosure when junior lien holders are maintained in that position because of the exercise of equitable subrogation, where a home equity line of credit holder or a junior mortgage is not entitled to not entitled to foreclose on a refinancing lender because equitable subrogation puts them into a position that's prior to the junior lien holder. Next slide, please. This slide discusses some of the policy considerations of the majority view, which is if there is actual knowledge, courts will not be inclined or fail to exercise equitable subrogation as a form of equitable relief. And this slide discusses that courts do not apply equitable subrogation where the refinancing lender had actual knowledge of an intervening lien at the time it paid off the prior mortgage. But they do apply equitable subrogation when the refinancing lender had only constructive knowledge of the intervening lien. So that's to say the intervening lien was recorded in the land records or in the public records and may or may not have been picked up by the title policy. One of the policy considerations that favors this majority view is that refinancing lenders, by and large, are sophisticated actors. And so if they are negligent in not picking up the junior lien or not paying off the junior lien, they should bear the consequences by not being able to take a priority position. Next slide, please. And the same is true for the minority view, where courts find that any knowledge, whether it's constructive knowledge or actual knowledge, will bar the application of equitable subrogation. There, the courts discuss that, again, a refinancing lender, by and large, is a sophisticated actor. And if they were negligent or if their title insurer did not pick up the junior lien, they should not be able to leapfrog above the second position. Next slide, please. Equitable subrogation largely overlaps with several other concepts that we see in title insurance litigation. It's most commonly applied to benefit refinancing lenders, as we've been discussing, but it's also applied in other circumstances, such as to impose an equitable lien in place of a defective mortgage. And Zach and Indira did a good job of discussing how in certain circumstances, if a mortgage is found to be void or voidable, that courts will impose an equitable lien to hold the position or hold the interest in the property that was intended by the mortgage transaction or the refinancing transaction. Second, equitable subrogation is applied to avoid unjust enrichment to a borrower whose debt was paid. And so there could be circumstances in which there would be a windfall to the borrower if the refinancing transaction was not realized or not recognized as an interest in the property, and then the borrower would be entitled to more equity than they deserve, and would be unjustly enriched if the interest was not preserved in the property. Another example of when equitable subrogation is applied is again to avoid a windfall and to protect the valid interest in the property. And the order of priority is maintained because the refinancing lender uses the proceeds to pay off the first position and intends to retake that first position. Another example is to permit a buyer or a purchase money lender to stand in the shoes of the prior lienor, and I won't belabor that point. And then the fourth or the fifth example is to impose a lien against the interest of an owner who did not sign the mortgage. And so there was a discussion earlier about a case in which a wife disclaimed that she had signed the mortgage or claimed that her husband had forged or fraudulently signed the mortgage. And in that case, courts will impose or are inclined to impose an equitable lien on the property to maintain the lender's interest or the mortgage holder's interest in the property, even where one of the owners, in this case, a husband and wife, did not sign the mortgage. It's important to consider, what is the end game? What is the strategy? And how does equitable subrogation interplay or interact with imposition of an equitable lien or an equitable mortgage? Oftentimes you see equitable mortgage and equitable lien pled in the alternative. I don't think they're inherently inconsistent. And so I often err on the side of the caution and plead them in the alternative. And if discovery bears out that equitable subrogation should be used as opposed to equitable lien or vice versa, you always have the option of it being alleged in the complaint rather than moving for leave to amend the complaint to assert a form of equitable relief. Next slide, please. I included one case study, and for those of us who practice in Florida, this is the seminal case that discusses equitable subrogation, equitable lien. It's a Florida Supreme Court case from 1993 called Palm Beach Savings and Loan Association versus Fishbein. In that case, the husband forged the wife's signature. And the husband used $930,000 of the funds to pay off 3 existing mortgages and taxes on the property. There was a divorce proceeding, I believe, and the wife refused to pay the new mortgage the husband had fraudulently obtained. And that mortgage, the bank foreclosed that mortgage. In the trial court, the trial court denied the foreclosure. It allowed an equitable lien for the amount of the taxes paid on the property and that portion of the mortgage that was used to satisfy the pre-existing mortgage. That case went up on appeal, and the intermediate appellate court reversed the imposition of an equitable lien. That decision was appealed to the Florida Supreme Court, which quashed the decision to deny the bank an equitable lien. It noted that the equitable liens can be used to impose, noting that equitable liens can be used and imposed in the absence of fraud, even against homestead property, to prevent unjust enrichment. And so the Florida Supreme Court allowed a lien on the wife's homestead property to the extent that the bank's loan proceeds were used to pay the pre-existing mortgage for which the wife would have been liable if the husband had not paid them. Next slide, please. And so that concludes today's presentation on equitable subrogation. I would invite any questions you have in the question and answer feature, or Tripp or others, if you have anything to discuss on the concept of equitable subrogation, I certainly invite that.
Yeah, I've had a lot of experiences in New Jersey, which actually is in the majority. Or I guess it was in the majority. I can't remember majority or minority, but that there is volunteer status is established if you know or should have known regarding the existence of the lien. But what happens in many instances that I've run into is, the refinance lender knows. It knows there's a first lien and they know there's a HELOC, and their intent is to refinance the first and to pay off and have discharged the HELOC. And what happens is that either the borrower has all the intent in the world to basically defraud that lender. It gets paid off at closing, and they know it hasn't been discharged yet, and so that borrower, homeowner, turns around and draws down the line immediately. And so what I was going to say is, in those instances, if that's happened, then, you know, in terms of litigation strategy, you have to be prepared to sue that borrower for fraud, maybe even breach of contract, on behalf of the refinancing lender. And you should also, of course, you know, make sure and follow the trail of the discharge documents, and so forth, so that you, if there is an issue of delay in getting a discharge document recorded, you know, you can follow that as well. So, all right, well, I think we're gonna, seeing no questions, we're gonna move ahead, even though we're slightly ahead of schedule, to our last presentation, which I'm going to participate in, but which Matt Haar is going to take the laboring oar, and that is the all exciting ethics portion. And I say that a bit tongue in cheek, but not in reality, because as with any insurance underwriter, title, P&C, or what have you, when the claims counsel or claims manager is signing out that matter to outside counsel, that outside counsel is the insured's counsel. It doesn't address coverage with that insured, nor can it speak to the claims counsel or manager about coverage issues. And that can many times raise ethical issues, not only relative vis-a-vis the outside counsel and the insured and the insurer, but also address issues, or issues will arise in terms of managing the matter. So you have a claims counsel, claims manager who is directing the litigation, which of course is perfectly permissible under the policy. In fact, that's what the policy says. And then there may be issues, however, about how that litigation or resolution of the defect is being handled. And so that gives rise as well. And so Matt and I will address that, but I will turn it over first to Matt to begin.
Thanks very much, Tripp, and welcome everybody to our last segment today. Tripp and I are very cognizant of the fact that we're what stands between you and lunch or whatever the rest of your day may bring. So we're going to try and keep this last section lively and certainly limited to our 12:30 cutoff. But again, this is the ethics portion of our presentation, and I think a large part of our discussion today is going to be framed by a lot of the developing law in insurance bad faith, and as we'll talk about probably more moving forward in the broader extra contractual world in reference to consumer protection laws, which in some ways are overtaking insurance bad faith litigation trends. So next slide, please. So why does bad faith matter when you're looking at ethical obligations of insurers and agents and other insurance professionals? And I would posit that it's probably in this day and age the most important, in essence, de facto regulation of insurance practices. There are certainly no shortage of regulations enacted by statute, further enacted by insurance departments through regulation, but the most current trends across the country, I think you see being developed more through litigation, policyholder litigation, and that, I think, is where we can learn a whole lot about our ethical obligations here. And again, why are we paying attention to bad faith? Because it often deals with punitive and treble damages. So exposures for companies and others can be significant and high. There's often provisions for things like an interest rate starting at the date of inception of a lawsuit at an inflated rate, 18, 24%, somewhere in there. There's also usually a specific provision for recovering attorney's fees for anybody who is successful on a bad faith claim. compensatory damages are an obvious element, but in a lot of instances, the case law develops a definition of compensatory damages that is very broad. In fact, in some instances, including attorney's fees within the realm of compensatory damages that are then eligible to be doubled or tripled as part of relief. There's also broad definition of what are consequential damages. And again, another leverage point is that a lot of these bad faith claims can be based on institutional or class action considerations. In other words, not just what a specific policyholder is bringing up in terms of a denied benefit, but where they allege and potentially can prove that it's an impropriety that's been imposed upon others. Next slide, please. So some common targets that we see for bad faith allegations against insurers. Usually, and you see a lot of this litigation primarily in the P&C world, if for no other reason than the vast majority, there are far more, I think, P&C claims being litigated than title insurance claims. But elements of claim evaluation and adjustment and resolution are critical parts of this. And one thing that I think it's important to talk about here is kind of the scope of varying bad faith laws. There's obviously not a single bad faith law that applies across the country. They vary from state to state. Some are relatively toothless in that they're not much more than the implied covenant of good faith and fair dealing, requiring a party to a contract to do, in essence, what they promised they would do. It's in essence a breach of contract claim and doesn't typically include things like punitive damages, attorney's fees. But also looking at the statutes, the bad faith claims, they also include things as powerful as statutes that specifically provide for these forms of relief. One thing that we'll talk about during the presentation today is the scope of who can be reached through some of these claims. And in the bad faith context, it's almost always limited to the insurance company. For example, in Pennsylvania, we have a bad faith statute, section 8371, and it's by its terms limited to insurance companies. It doesn't include agents. It doesn't include any other potential parties. It's just insurance companies. It also is defined only as denial of benefits. So there can, for other types of insurance, there might be other things that make insureds unhappy. For example, having a policy non-renewed. But with, at least in the Pennsylvania statute, things like non-renewal are explicitly written out of what could potentially be bad faith. But keeping going here on some common targets, one thing that policyholder counsels often seize on is, was there appropriate training and education for people who are adjusting and acting on claims? Certainly company policies are ripe for these types of claims as far as how claims are brought in, adjusted, communications patterns with insureds. And another popular theme among insured counsel is performance and compensation criteria for claims adjusters and other folks who have influence over claims. Now, a common theme among policyholder counsel is these agents are in essence rewarded or promoted or given bonuses when they deny claims. And having litigated these claims for upwards of 20 years, that's clearly, I've never seen an instance where that's been explicitly the situation, but there have been some situations where that allegation has found at least some facts that make it somewhat colorable. Next slide, please. So what are the insurers' motives that often get them into these positions? Another way of looking at this is what types of themes can insurers develop to combat bad faith claims? Or put another way, how is it that insurers can fulfill ethical obligations and act in good faith towards their insureds, toward third parties, toward insurance regulators? Obviously, one thing that all insurance companies try to do is pay covered claims, because that's why they're in business, but also to make sure they're not paying uncovered claims, because that's not part of the business model. Now, obviously here, there's some issues with if these cases go in front of judges or juries, you have a policyholder who's often sympathetic. We know from experience that insurance companies are not the most popular folks with juries and often judges, but with an appropriately themed defense, you can explain why it is that insurance companies have a clear motive to not pay uncovered claims. Relating to this is, everybody knows that there is a significant amount of insurance fraud, and that companies in the first instance have to take significant effort to make sure that they're combating that, because it doesn't just impact them, it potentially impacts other policyholders. Insurance companies, in the same vein of making sure they don't pay uncovered claims, they don't want to pay exaggerated claims. They have a duty to understand what damages are and aren't covered and make an appropriate decision there. Obviously, insurance companies want to eliminate waste in their operations and conserve resources. One theme that we typically see in bad faith claims is the plaintiff alleging that all decisions were made with the end goal of making a profit for the company. And there is a narrative that needs to be part of these defenses, that's not a bad thing. We want insurance companies to be making a profit because we want healthy insurance companies in the market providing the very valuable service of coverage. Next slide, please. One thing here to keep in mind, it doesn't matter how well intentioned a policy is or how well it works overall. Policyholders Council is always going to focus on what's the impact on a particular plaintiff. And a lot of times, again, even though there's a good reason for a policy, if you have a single policyholder in front of a judge or a jury, you're going to have to explain why it is that it's fair that this person in essence loses out for the benefit of everybody else under the policy and the company following policy provisions. And again, another thing that we know happens is people within companies, claims adjusters and others, most of the time follow policy strictly, but there are instances when they do not, whether intentional or unintentional. And I think one of the things that would be a takeaway that'll, if we get to the takeaway slide at the end of this, I'd throw with you, a company's strategy for proactively addressing potential bad faith and consumer protection claims is only as good as the ability and willingness of their agents and other people acting on their behalf to follow through on that policy. And that's why it's very important to consistently review and update internal policies to make sure that you're keeping up with all of the current trends. And there's a lot of ways to do that. Obviously, having folks engaged in the industry just beyond their company, being involved in trade groups, attending things like this CLE to understand what's going on out there in the marketplace. Next slide, please. Here's a slide just on where we see a lot of potential for bad faith claims and where there's often an allegation of lack of institutional control. Obviously, new agents are frequently an issue because they're coming up the learning curve to understand what's going on. In many instances, the agents have a lot of claims that they're dealing with. They don't get perhaps as much time as they'd like on each individual file, but I think it's incumbent upon the insurance companies to make sure that the newer agents are getting the training they need up front, but also as they develop that they have a support structure within the company to make sure that to the extent they're encountering issues, there's a way for those to be appropriately addressed. Probably one area where we see a very significant number of bad faith claims is where an agent is leaving the company, either where they've kind of made a decision to leave and they've not yet left, or they've announced that they're leaving and they're just winding up some files. I think one of the trends we hear about in the news is this quiet quitting concept, and I think this plays into it. There needs to be a way for managers and executives within the companies to keep an eye on exactly what agents are doing, to be a resource for them, and to make sure that they're handling claims appropriately. One thing that we know is popular within a lot of insurance companies, but is also a frequent target of bad faith claims is roundtables. It kind of goes with what I was just talking about making sure that agents are appropriately reviewing claims. And it's a great way to get other more experienced folks input on how to deal with a claim, but there's also a potential and sometimes an allegation that roundtables are also an opportunity for kind of groupthink. To stay within a regimen rather than to think beyond it. And again, the last point here, there's also often a theme among with claims that the purpose of a roundtable isn't to get it right. It's really to bring in other people to find reasons to deny or reduce a claim, which again is not what our experience is when actually dealing with insurance companies, but it's a frequent theme among policyholder plaintiffs' counsel. Next slide, please. So again, opportunities to proactively combat against bad faith. Reviewing policy and procedures periodically is critical. Also, it's important to try and come at it from a perspective of not just an insurance professional, but try and think about what others who really aren't as conversant in the industry would think of things. An example I usually throw out here is many years ago, again, I think this was really entirely in the P&C space, that there was a program developed called Colossus. I think the idea of which was to allow companies to be able to put in variables related to personal injury claims, and from that get a starting point for a discussion on what a person's damages would be. But you know, the name itself sounds overbearing, and the program, at least the allegation was, developed into something that insurance companies took as kind of the end-all be-all evaluation of a claim rather than a starting point. Making sure that policies and procedures are being followed as intended is critical. Part of that is periodic training, and also insurance companies looking for ways to improve. Everything from simple suggestion boxes to committees and such within insurance companies to review policies and try and bring new trends to light. Next slide, please. Again, more of the idea about combating bad faith proactively. I think part of the education element needs to be talking about case law, because I really believe that developing cases on bad faith and consumer protection are the cutting edge of these issues. Encouraging staff, everybody from claims adjusters all the way up to top executives, getting them involved in professional and community organizations is very helpful, because they're thinking beyond just the narrow scope of insurance and interacting with folks for whom this is not the primary focus of their professional life. And especially post-pandemic, the need for folks to be tech savvy in all aspects of claim handling is increasingly critical. Next slide, please. And I want to jump here to a related field of unfair trade practices, because as I think I indicated earlier, I think the law on unfair trade practices is almost eclipsing the developing law in bad faith, simply because it gives folks an ability to recover with a far lower standard than bad faith. Typically with bad faith claims, statutory in nature, there needs to be clear and convincing evidence that an insurer intentionally and knowingly disregarded a situation where they should have been paying a benefit. And as we're going to see from our discussion of unfair trade practices, it's a very different ballgame here. Another thing, though, to consider about unfair trade practices, and we'll get into this a little bit, is who can be involved. I mentioned earlier that bad faith statutes typically are directed only to insurance companies. Unfair trade practices have no such limitation. They apply both to companies, to agents, to claims handlers. So there's a greater opportunity for more parties to be brought into litigation here. But just a little bit of history in Pennsylvania, which is relatively indicative of Unfair Trade Practices Act around the country. Back in the 1960s, there was a Uniform Deceptive Trade Practice Act, which was adopted about 2 years later in Pennsylvania as what we call the UTP-CPL, the Unfair Trade Practice and Consumer Protection Law. Next slide. We also have related statutes and regulations. There was the NAIC Unfair Trade Practices Model and the Unfair Claims Settlement Practices Model Act, which at least in Pennsylvania were enacted through the Unfair Insurance Practices Act. The thing to keep in mind about that is it does not include an ability of a private litigant to recover under this, but a proven violation of these statutes is per se a violation of the Unfair Trade Practices Act, which does have a private right of action. Next slide, please. So probably one of the biggest questions that we're going to address here, and we're going to look at some cases on this. A big question is, what is an unfair or deceptive practice that would give rise to liability under this act? And I don't know if there's any Simpson fans out there, but the picture here is of the character attorney Lionel Hutz of the infamous law firm I Can't Believe It's a Law Firm, who was representing Mr. Simpson and said, "Mr. Simpson, this is the most blatant case of false advertising since my case against the Never-Ending Story." And while it was amusing, while it was in The Simpsons, I think you'll see as we go through the discussion on some of these cases is that it's not so funny, because we seem to be getting closer and closer to something like this as far as what is unfair or deceptive. So next slide, please. So talking first about the Unfair Trade Practices statute, it has some defined practices that are considered unfair or deceptive. In Pennsylvania, there are 20 or more, there are 20 enumerated practices plus some. If you look at these statutes across the country, most of them have the same first 16, 17, or 18. And after that, there are occasionally a couple added, which I'm gathering were because there was a specific issue in a specific state where there was a practice where somebody deemed it appropriate to make sure that that was explicitly forbidden. But these enumerated practices are things such as an insurance company threatening a policy holder that they will appeal as part of a normal course of dealing with litigation rather than dealing with each individual case on the merits. But where the real teeth of these consumer protection laws are developing now, and where they cause, I think, the greatest cause for concern for insurers is what's called the catch-all provision. And as it's currently written in the Pennsylvania version of the catch-all provision, what is prohibited is fraudulent or deceptive conduct, which creates a likelihood of confusion or of misunderstanding. And we're going to get to two cases that explain to us how this has really developed to lower the bar and lower it again for policyholders and others potentially impacted by conduct that could be considered confusing on the part of insurers or others. One thing to point out here, and we'll get into this in a case in a little bit, the statute as originally written in the catch-all provision prohibited fraudulent conduct, which creates a likelihood of confusion. What was added in 1996 is the phrase "or deceptive." And so we're now dealing with a catch-all provision that prohibits fraudulent or deceptive conduct. And we'll see in a minute or two some of the cases that show us how that has expanded the reach of these statutes and made them far more dangerous to insurers. Next slide, please. The prior view of the statute, when it only prohibited fraudulent conduct, was that what it meant was the act applied to what was normally considered common law fraud. And I think that was a fair reading of what the statute said. It prohibited fraudulent conduct, so courts, without any other definition of fraud, looked to the common law view of fraud for what had to be proven. For those of us who are primarily in the defense bar, that was pretty good, because defending against something where a plaintiff has to prove intentional conduct by clear and convincing evidence, that's a tough standard for plaintiffs to meet, even at the pleadings stage. So those cases were, on a spectrum here, relatively easy to defend against. And we'll see as these things have evolved why that is no longer the case. And again, these cases are becoming more prevalent, more difficult to defend, and the end result being these cases provide far more stricture for companies, managers, agents in dealing with claims by policyholders and others. The interpretation with the change in 1996 to add the "or deceptive" language is that courts figured out that there's something other than fraud that can trigger these, the UTPCPL and the teeth behind it. The case here is this Bennett versus AT Masterpiece Homes that was decided by the Superior Court in 2012. I think it bears here a little bit of the history of this case. In the case, there were two plaintiffs who had homes built for them by this company, AT Masterpiece Homes. And while the name of the company would suggest to you that at the end of the day, these folks should have had a home that was a masterpiece, I think we can tell by the fact that this ended up going to a Pennsylvania Intermediate Appellate Court that is not exactly what happened. So the home buyers brought suit not only against the company that built their homes, which was an LLC, but also against the principal who was behind that company. So here again, this highlights one of the differences when we're moving from bad faith into the consumer protection laws. It's not limited to the company with whom they were in contractual privity. It's another person. And I would posit two reasons why that was in this case. One, a lot of times you will see an individual named as a defendant to defeat the possibility of removing a case from state to federal court. That may have been a reason here, probably not, but maybe. It's certainly a reason that could be used going forward. The other thing that I think that is more likely is the home builder was an LLC which was probably designed to limit any liability. So they were going after the principal behind the company because at the end of the day, he may have been the only person with resources. But again, keep in mind here, the consumer protection law claim enables you to name not just somebody you're in a contract with, but others. So in the title insurance context, think, closing agents, others that were around the deal, may have made statements and all that. But in the Bennett case, the allegation was that these people recognized that there were issues with their homes while they were being built. They spoke with the principal behind the company, who, at least according to the opinion by the Superior Court, made assurances to them that we'll take care of everything. You've got nothing to worry about, that the house will be just fine. And obviously, they didn't think the house was just fine at the end of this. And this went to court on a theory that that principal of the company, by telling these homeowners that everything would be okay at the end of the day, subjected himself to personal liability for his representations, not because they were intentional, but this is where you really see the Pennsylvania courts really sink their teeth into this or deceptive language. They said that there's something else here. By the legislature adding those two words, we can't view them as entirely surplusage. We have to give those words meaning, and what we think those words mean is that this includes negligent conduct too. So not only is that obviously a far easier burden to bear, that somebody was negligent as opposed to intentionally fraudulent, it's also something that can be proven by a mere preponderance of the evidence, not just clear and convincing evidence. So this case went up to the Superior Court. The case was decided in 2012. And one of the things that the Superior Court looked to was the federal courts in the Eastern District of Pennsylvania had kind of picked up on this before, and there were 2 or 3 cases there that said, we think that the Pennsylvania state courts are getting it wrong by still insisting that there's this required level of fraud. It can be negligence too. And the Superior Court in essence said, yeah, we've been getting this wrong since 1996 when this new wording went in there. This really does mean that negligence is all that you need to prove in order to recover under the Consumer Protection Law. And again, if you compare this to the typical bad faith statute that requires clear and convincing evidence, you now have an area of recovery for folks against insurance companies and now others based on a considerably lower burden and standard of proof. So again, how does this implicate the ethical obligations of insureds and folks that they work with? It's not merely enough to, I think, requires them to redouble their efforts to make sure that their interactions with consumers and others satisfy the obligations that these cases are showing us are out there. So that's the Bennett case. Next slide, please. Again, let's compare what was required under bad faith law versus now what's required under the UTP-CPL. Under Pennsylvania's bad faith statute, the insured had to prove both that the insurance company, only the insurance company, was on both a subjective and objective basis acting unreasonably. In other words, is there something out there, is there a comparable case that showed the insurance company that what they were doing was inappropriate, where they should have known about that, and that cannot be proven by clear and convincing evidence. It's a tough but not insurmountable barrier. Under the UTP-CPL claim, under the new reading through Bennett, the insured only needs to prove that the insurance carrier or others, if they'd care to name them, was deceptive or misleading by a preponderance of the evidence. So decreased burden and standard of proof for insured translates to requirement for insurers and their business partners to redouble efforts to make sure that they're meeting these expectations within the market. And again, these are not necessarily standards that are written out explicitly by either legislatures or regulators. These are standards that are coming in as alleged by plaintiffs' counsel, as articulated by expert witnesses, and alleged to juries and judges. So next slide, please. So contemplate here, can UTP CPL claims now be an end run around claims for bad faith in the absence of coverage? One of the concepts that I always like the name of it anyway for bad faith law is, do insurers have the right to be wrong? In other words, can you deny a claim but not have bad faith liability because you had at least a good faith basis for denying the claim? And in the bad faith context, I think the answer was generally, almost universally, yes. You can be wrong on a claim but have it not be bad faith. Now in the consumer protection context, as that standard is being opened up, can you have a situation where maybe the insurance company is correct on its reading of a policy and whether something should be covered, but is there still an independent basis for an insured to recover because either a practice, a communication is otherwise deceptive or misleading? Again, I can't point to a specific case in the title insurance industry where there's been found to be deceptive or there's been liability for deceptive or misleading conduct. But as we're going to get to here in a second with another case, it has been found in a very similar situation. So here again, question, is the focus now becoming on, from the consumer's perspective, what is deceptive or misleading versus what's standard industry practice, what is standard industry reading of insurance policies and provisions. So next slide, please. So kind of following up on my use of Homer Simpson and Lionel Hutz to talk about what's deceptive and what's misleading, I'll borrow another TV line here, but wait, there's more. There was a very recent case in Pennsylvania on the UTP-CPL. We have it cited here, that the Gregg versus Ameriprise decision. This was decided about a year and a half ago by the Pennsylvania Supreme Court. So this is now, with the Superior Court, there's at least a little bit of wiggle room as to how far that applies. With the Pennsylvania Supreme Court, it's very clear that this is now the law of the land in Pennsylvania and has to be respected as such by state and federal courts everywhere. But the case here involved, the plaintiff was a couple that was seeking financial advice, and they went to a financial planner who laid out for them a plan involving purchasing a specific form of life insurance, putting money into various mutual funds, and there was a whole plan ostensibly laid out. What the court decision tells us is, obviously, at a certain point in time, the plaintiffs became dissatisfied with what they were seeing, and what they've alleged and what the Supreme Court gives to us in relatively conclusory fashion is that they thought that the plan that was being laid out for them was not followed explicitly by the agent, even though it is specifically cited in the case that they told the agent he could do whatever within reason what he thought was best in investing in these various vehicles. I think one of the big hooks here for the plaintiffs was most of what the agent was directing the monies to were funds that had an entry fee of 5.95%, which directly impacted how much money the agent was getting up front for facilitating these investments. But in any event, the plaintiffs, the consumers, alleged that they didn't believe that it was explained to them appropriately where this money was going to be going and exactly how it was going to be invested. This case went to trial in Allegheny County, which is Pittsburgh, and the jury returned a defense verdict on the common law claims, which were fraudulent representation and negligent misrepresentation. So you have a clear decision here by the fact finder that both the company and its agent, are not liable on these common law claims for misrepresenting or leading astray the plaintiffs. But what happened was the judge who was hearing the UTP-CPL claims is part of a concurrent bench trial, despite the finding of the jury, entered a decision for the plaintiffs on the UTP-CPL claim. What the judge determined was the standard for UTP-CPL is not really negligence, it's really strict liability. And the standard is not necessarily it's certainly not the defendant's state of mind, whether there was an intentional or a reckless disregard with misrepresenting something to the plaintiff. The standard is, again, strict liability. Was there a likelihood, given what the defendant represented, that there could be confusion on the part of the consumer? So next slide, please. This is a standard that is almost impossible, I think, in all instances for defendants to meet. And this went all the way up to the Pennsylvania Supreme Court, and that the Supreme Court held that indeed strict liability applies to these catch-all situations under the UTP-CPL. So no longer do you need to prove fraud, no longer do you need to prove negligence or recklessness. There's a strict liability threshold where you just need to establish that the standard here is a likelihood of confusion or misunderstanding by the consumer. So I think that this case was a real wake-up call to folks who defend these types of claims. And where does this take us kind of going forward? Well, especially in state courts, maybe not quite as much in federal courts, but in state courts, it's going to be very easy for a plaintiff to at least get past the pleading stage with these types of allegations. They merely need to say, this was my interaction with the company, with the agent, and now looking back on it, and we wouldn't be here if there weren't a denied claim or something similar. I was confused about what happened, and unfortunately, that's going to get folks over the hurdle, I think, in most instances.
And Matt, can I just interject that?
Absolutely.
That it may seem a bit strained to say, well, what does this mean for the management of title claims? And I think that what the audience needs to keep in mind, and first, while you've approached it from a Pennsylvania standpoint, New Jersey has the exact same standard, likelihood of confusion. Massachusetts has that. I believe Maryland does as well, and I certainly know that Illinois does, and as very protective of consumers. And so when you're dealing first with a coverage determination, and say there is a denial of that, and it's run up the flagpole and so forth. But that denial by the court turns out, they bring a claim and they say, no, that was confusing. The way you provided me with an understanding of why the claim was denied, it was confusing to me. And that resulted in XYZ type of loss by us, because I didn't push you on it. I didn't seek a necessary declaratory judgment that there was coverage. And now I'm sitting here and I have some loss, and therefore it was your confusing description and or mistaken description of the basis for the denial. That's number one. And number two can also be, hey, claims manager, you took over, you're managing the litigation, and I really didn't understand the strategy. I understood it when you told it to me, but then later the litigation didn't turn out the way I thought it should, and I was confused as to that strategy. And since you directed my outside counsel effectively what that strategy was, although I had input, I would have had different input if I understood your statements a little more clearly. And so I think, just to bring it home to those who are listening, those are just two of the examples of how a claim for under these type of statutes, Pennsylvania, Maryland, New Jersey, Massachusetts, and those are just the ones that I know of that are particularly that use this standard, how it can come to bear. And so on the ethics side, again, it's sort of a scary thing if the court says it's strict liability, but it does raise important issues for interactions with your insured that at least attempt to address and these type of potential liabilities, whereby you're using very clear language. You're addressing these perhaps within a group so that it's the best type of language is being used, the most clear language is being used, and that there's sort of a there's no way for someone to say that you acted negligently, whether they were confused or not confused. That's going to be, again, a decision for the fact finder. But I just wanted to bring it home to those who are on the call.
Yeah, thanks, Trip. Yeah, I think one way that this really kind of manifests itself in-house anyway with title insurance companies is if you get a claim and you look at the black and white lettering of the policy and you're forming an opinion as to whether or not something is covered, I think you at least need to take into consideration is the insured telling you that there are other things. For example, did the title agent say to them somehow, well, if you've got this kind of claim, you're taken care of. Something that would follow that Masterpiece Homes case where you're having somebody make assurances kind of outside of the contract. Under the Gregg case, I think you at least have to evaluate that as to whether or not it's an independent basis for liability. So next slide, please. I'm going to kick it over at this point to Trip to talk about the relationship between assigned counsel and claims counsel.
Thanks, Matt. So as I said at the onset, the outside claims counsel have a very defined role, and that is to provide a strategy and carry forward that strategy for the resolution of either the defense of priority or whatever the other litigation may be, and is doing so not as the company's attorney, but as doing so as the insured's attorney. So, the letter of that, or the coverage letter that goes out should explain that to the insured. It should explain that the issues of coverage and specific decisions about where to take the litigation, whether it's settle, whether it's other actions, whether it's an appeal, those are are issues and questions and concerns that are really supposed to be dealt with between the insured and the underwriter. Of course, while I say I understand that relationship, perhaps there are outside counsel who don't quite understand it. So it is, I wouldn't necessarily say that you need to, every time you engage outside counsel, you need to remind them of that. But of course, there's typically a retention letter that goes out, and that language can be in there, so it at least is expressed. And then if the issues arise, which become coverage issues, there's nothing wrong, of course, with claims counsel to say to their outside counsel, look, this is a claims issue, and I know that you're not supposed to be discussing that with outside counsel. You shouldn't be giving them either discussing it generally or giving them advice on issues that are claims issues. You're not acting as their counsel to provide them advice with respect to their interaction with the insured regarding claims issues. And certainly along with that goes with expectations that you have for your outside counsel. You want to make sure that they're reporting consistently on generally and on issues, so that in fact, if the insurer calls you and has questions, you can answer those questions. They should also understand whether there are certain things that you expect of them pre-suit, during the lawsuit, and certainly with respect to resolution. They're not out there, even though they are the insured's counsel from an ethical relationship, they still need to take direction from you, as long as that direction is consistent with the policy language. Next line, next slide. So even where there is, and this is not necessarily typical, but even when there are coverage letters that say we're going to provide you with coverage and we have outside counsel that are going to deal with the resolution of this issue, and there's no reservation of rights, again, there needs to be an understanding of the relationship between outside counsel and claims counsel, so that they, again, understand the delineation between being outside claims counsel and coverage issues. And I think that, sort of dovetailing into what Matt had talked about earlier, is that everyone needs to be on board with the strategy, and a lot, I find a lot of times, especially when it's residential mortgage claims or priority claims or boundary claims of sorts, sometimes I think it's almost inherent that that claims counsel and outside counsel sort of talk about what things are going on, and there's not a great deal of communications with insured, because they really don't have much to offer. You know, they don't know the strategy. They don't know the law. There's not a lot of fact discovery that you need to obtain directly from the insured, but that doesn't mean that the insured shouldn't be kept apprised of what is going on. Obviously, you know, maybe it's a boundary dispute or an easement, and so there's not a whole lot of potential things that could occur during the litigation. But in a commercial situation, that changes. If the insured is trying to continue their development of a piece of property, or they want to mortgage that piece of property in order to get other financing, strategy in that litigation is really important. They need to know what is going on, because if they don't know what's going on, they could be making decisions or not making decisions that actually increase consequential damages. And so you may start off them as a matter with, say, a mechanic's lien, but then that developer wants to do something, or owner of the property wants to do something with that property. And the idea of appealing decisions, they don't want to do. And so they need to understand what that strategy is that you have with outside counsel, so they can talk to you about coverage. And if they're not being told, they can't talk to you about coverage, and therefore you may give rise to either a bad faith claim, or more importantly, as Matt pointed out, claims of unfair and deceptive practices. And again, maybe that language of unfair and deceptive trade practices in your mind doesn't sit directly on top of that relationship, but I guarantee you there's plenty of plaintiffs' counsel out there who will find a reason that it does. And so again, it's important to have that constant communication with the three legs of this stool. Next slide. So we talked about sort of where there wasn't a reservation of rights letter. There also needs to be communications with outside counsel about where there is a reservation. And outside counsel knowing about what those reservation of rights are, that's okay. That's not some sort of some boundary that can't be crossed. In fact, it's good to know, for example, that outside counsel aren't being retained for a fraud claim, or aren't being retained for some other claim, so that they don't go and start to litigate that in any capacity, one way or the other, and then give the insured unreasonable expectation that outside counsel is actually handling that for them. And therefore, when you guys find out that, oh, that was a mistake, and then the insured say, well, whoa, I didn't get counsel because of that. Notwithstanding that there's a reservation of rights letter, if you act different than that reservation of rights letter, then that's gonna build an expectation, and I think not an unreasonable expectation on the insured, that they have coverage for that. And then when you pull that back, that of course will cause some problems. In terms of I have here notice of continued claims investigations. That is how I've been involved in both sides of that, where I am investigating the claim while litigation and outside counsel are doing their work to help resolve the claim, or at least portions of that claim. And I've been on the other side where I'm outside claims counsel, and I know that there's still an investigation. Knowing that is one thing. Obviously, there's no need to describe and explain to outside counsel what that process is, or necessarily what the ultimate resolution, or where you're heading on that resolution. If you find that there is coverage of another aspect of the case, or you've confirmed that of what the outside counsel is doing, then there's really nothing needs to be done. If you find that there is no coverage and you're going to pull that coverage, again, there's no need to explain to outside counsel why that's happening. But what you do need to do is make sure that it's very clear to insured why you're pulling coverage. And again, one of the ethical issues here is how long do you wait? How quickly do you resolve those coverage issues through the investigation, and how you're communicating where you are in that investigation with the insured, because you certainly don't want to extend that period of time and then decide that you're going to pull coverage at an inopportune time for the insured. So again, those are issues to think about as you are trying to strategize and move forward with that investigation. Next slide. We talked a bit about this, is where you have coverage counsel for some of the claims, but then you're not providing counsel for other claims, and full well, both you and outside counsel, that the insured has their own counsel for those claims. Again, I've been in situations where insureds counsel and what we call independent counsel or private counsel is dealing with the fraud claims or the tortious interference claims. And, you know, the lines can be blurred. And so my recommendation is for you guys is to consistently communicate with your outside counsel about how they are interacting with the private counsel. What's their role, and so forth. And of course, explain that outside counsel the private counsel may also be their coverage counsel. And so you have to be careful that you're not divulging coverage issues to your claims counsel, which then inadvertently get disclosed to the insured's claims counsel. So I think that addresses that slide. Next slide. I think I'm going to turn that back over to Matt, and we have just about 5 minutes, so I'll turn it over to Matt.
Thanks, Trip. Yeah, I'm going to bring this home very quickly. Just a couple more things to touch on. I'll just go over this in the most brief terms. Discovery, as it's related to bad faith claims and consumer protection law claims, it can be very broad. And that is, again, something to be thinking about early on in the process. You don't want to get down the road so far that it's something that you can't control. I have the phrase up here, think ahead of the airplane. You can't just think about where you are now. You need to be thinking about where a dispute is likely headed and what it may mean in terms of discovery. There are ways to deal with broad discovery. There's concerns with undue burden, proportionality, and all that. But this has got to be part of your analysis and discussion if you're evaluating the potential of claims go into litigation. Next slide, please. Experts, also something to think about in the field of either bad faith or consumer protection law claims. One of the biggest things from my perspective is if you're going to hire an expert, what exactly are you hiring them for? So courts are typically not wild about hiring an expert that is like a former insurance executive who is basically going to parrot what any company witness is going to tell them. So you need to think about if you're going to bring in an expert, other than somebody from inside the company who obviously has some level of expertise, what is it that they're trying to help the trier of fact understand? And in what way can they explain something that is outside of the scope of knowledge of most folks? You also need to consider to what extent the person's testimony is coming from generally accepted fields of study. Next, please. Again, just thinking about who you may want as an expert, I always look first to somebody inside the company, not only because they're familiar with the claim and the issues involved, but they generally have a background that you're just never going to be able to give to an expert, an outside expert to talk about things. Next slide, please. Issues with attorney-client privilege. Again, this could be its own CLE, but keep in mind, you want to take advantage of the attorney-client privilege as much as possible to shield things from discovery and make sure you're getting appropriate advice when dealing with issues. I see far too often people thinking that conversations, emails, whatever, are covered by attorney-client privilege merely because an attorney is part of a meeting or on an email string. And that is certainly not the case. The key elements of attorney-client privilege, no matter where you are, is who's the client, are they seeking advice, and is the communication being made in confidence to impart that advice. Next slide, please. And next slide. And probably the most important thing here is our final CLE code, 43759. And we'll leave that up there for just a minute or two. Just a last parting shot from me. When you're talking about privilege, discovery, a lot of these other issues, especially as it relates to attorneys, technical competence is not merely important, it's required by the rules of professional conduct. So that applies to whether you're in-house or outside involved with these claims. So with that, I'm going to kick it back over to Trip to close us out and just say, thanks for being such a great audience.
Thanks for all of our speakers. And thanks for all of your attendance here. I hope that you gained at least one valuable insight, one valuable takeaway. And I would just say that to the extent that you guys have any questions, comments, concerns, you can reach out to any of us or to me. And we look forward to talking to y'all real soon. So enjoy the rest of your week.